All right, all right, all right. Looks like we are live. What is going on, Bree Hive? Welcome back to yet another Bree Hive Live. We are back on a Tuesday live stream, and I'm hoping that my computer does not shut off because I have been having technical difficulties with Wi-Fi. But nonetheless, the show goes on. Hopefully, we don't get kicked off and put back onto the iPad like we did last time. Anyways, today we are going to be covering some interesting things that have been happening over the last week. We had Hannah Gutierrez Reed, who was sentenced yesterday for the Rust shooting trial. That she was just found guilty and convicted guilty of. And then we also have Bryan Kohberger. There's been a lot of movement going on in that case, and I know we haven't been able to cover it every time something new comes out, but there is some movement going on with the surveys that they are putting out to the jurors. So we're going to check out what's going on over there. This one is going to be a live reaction to Hannah Gutierrez because I have not watched any of the sentencing. But for Bryan Kohberger, I did go ahead and watch a lot of the arguments that the attorneys had prior to the hearing regarding the survey. Answer the surveyor answering questions, and then we got into the surveyor answering the questions and arguments about when things are going to be. Now, it looks like people got kicked out of the live stream, so hopefully y'all all make it back. I know some people in the chat was saying that they're having some troubles with YouTube today. I'm having troubles with my Wi-Fi today. Hopefully y'all make it back in. I don't know if they sent y'all to a commercial break or not, but all of a sudden everyone that was watching live just disappeared. Anyways, let's go ahead and jump into who's watching live in the chat. If you haven't already, go ahead and drop something in the chat to let me know that you're watching live so I can say hello to you. And if you're watching on the replay crew, go ahead and drop it in the comment section so that I can see who's watching on the replay crew. We are trying to get that going as well as far as having a good replay experience. So please, if you're watching on replay, go ahead and let us know that you are here. We are going to set our like goal for the stream, and I think my Wi-Fi is going to cut out, y'all, and I'm so sorry about it. But it is giving me a sign that Wi-Fi is not doing too healthy right now. So if I cut off, Wi-Fi is the reason, okay? Wi-Fi will be the reason. Anyways, like goal for the stream. We are already at 14 likes, and it is showing me that only one person is watching live. So I'm thinking that YouTube kicked people off because it was just like 20 people watching live, but that's okay. We're gonna go ahead and make the like goal for the stream 75 likes because I'm hoping that all of our Bree Hive live people pop back on here and we can make the like goal reach where we want it to go, which is 75 likes for the live part of the live stream. So we got about 3 hours to hit 75 likes. I'm going to go ahead and say hello to everyone that was in the chat. And hopefully that will be coming back to the chat. So let's go ahead and have Bossy B come on in and bring us in for the chat. All right. I see some people saying what's going on. It's the YouTubes, y'all. It's the YouTubes. It's my Wi-Fi. I don't know, but everyone got kicked out. So hopefully everybody comes back. We got Alexis Carney, member of the channel. Hello. Welcome into the live stream saying first comment, tag your it. Thank you for stopping by early to go ahead and drop the first comment. We got Weird Pisces, another member of the channel saying hi. Second, hello. Welcome in. Alexis Carney says, dropping the B. Hope you're having a good day. Looking forward to Bree's take on Hannah Gutierrez Reed. Now, this one is going to be a live reaction because I have, I don't know what's going on in my backstage, but there's some weird stuff happening here. YouTube Wi-Fi, please get it together. Let's not have technical difficulties. Okay, let me get my brain together. Okay, so yeah, Hannah Gutierrez Reed is going to be a live reaction for me because I have not actually watched what happened on there, and I'm like hearing bubble noises. I don't know what's going on backstage. Okay. I have not actually watched that one, but I have seen some of our favorite other lawyers on YouTube commenting on this and some other people giving out some information. So I'm interested to see what happens. And about those phone calls, I don't know how much it gets to. I don't think they go too deep into it on the sentencing hearing. On the sentencing hearing, we might jump around a little bit so that we can cover the most relevant. Well, I mean, I guess they're all relevant, but like the mom, the sister, where we might jump around and cover those kind of statements because I am not trying to be here all night. Leela Wells, another member of the channel, saying hi, hello, welcome in. We got Weird Pisces saying, has anyone seen the video on Arizona judge walking off the bench while a proffer, maybe spelt right, was being put on the record? I have not seen this. Weird Pisces is also a member of the channel. Welcome in. I have not seen that today. Mary Malarkey, member and moderator of the channel, saying, I've been following the Kohberger case since the start. It's hard for me to keep up with it with all the other cases that come out because I don't want to just be sitting there waiting for something new on Kohberger. So I'm happy you've been able to keep up with it. Hopefully some other favorite lawyer YouTubers are following the case. I don't know. Kimmy, are you getting weird feedback on your end? It is showing me weird things back on my side. So let me know. Let me know what's going on. Let's see. Mary Malarkey says to Weird Pisces, I caught that on Peter's channel last night. Unbelievable and literally jaw-dropping segment on the one where they walked off the bench. Weird Pisces says the judge again, I don't know what happened before, but limited the defense to 5 minutes, but not the prosecutor, and allowed it to keep going. So is that why he walked off, or are you talking about something else there? Mary Malarkey says it's a must watch. I'm going to have to find it. Weird Pisces says, I know the judge just walking off the bench, then taking a man away from the cross because she made an objection for the record. That makes sense. Okay, let's see. Okay, so Kimmy saying it's playing fine on her end. I see comments and chats coming in, but also I think a lot of people got kicked out. So I don't know what's going on with the live stream there. Okay, let's see, where were we at? I just want to get to the stuff that we're talking about. Tanya D, member and moderator of the channel, welcome in, says that judge was way out of line. If lawyer was mad, he was doing too much. Yes, of course. See, Ty, another member of the channel, hello and welcome in. We got Baby Meatballs, another member of the channel, hello, welcome in, saying, hey, friends. Carolyn Lower saying, thanks to Tanya D and Mary Malarkey. I might have missed something up above. Phoenix Waller, another member of the channel, saying, I've only caught bits and pieces of the Arizona judge, but woo boy, he's asking for either a mistrial or an appeal. Is it a trial that's going on and he just walked off? Weird Pisces says, I'm not up to date on that case. If he is found guilty, I hope he gets a retrial. So if he is found guilty again, it was because of a fair trial, not because the judge just left the room, right? Not because the judge left the room. Tanya D saying to maybe Meatball has entered the chat. Carolyn Lower says there's no way this doesn't get appealed. I mean, yeah, just leaving the bench is a problem, right? MZ says, hiya all, popping in for a while and hitting the like, but will mostly be lurking and listening intently with earbuds. Welcome in. Nice to have you back. We had a little bit of technical difficulties in the beginning, but we are getting the stream moving here. And again, it's showing me weird things on my end, but let me see here. I know you guys were chatting a bunch while I was trying to get my life together, so I'm really, really behind in the chat. So if I don't say hello to everyone, I am sorry. I do want to jump into the chat. Let's see. We got a couple more people coming in. Chelsea B, another member of the channel. Hello, welcome in. And say, I can't like the video. It says quota exhausted. That's weird. Like literally my live stream is saying that 3 people are watching, but I can see that there's more than 3 people commenting. So I don't know. I don't know what is wrong with YouTube. It keeps saying 0 to 3 people watching. And I see that there's more than 3 people commenting. So I don't know what's going on with YouTube today. I just reset my Wi-Fi because that was acting up. And now we can't even like the video. I'm sorry, y'all. I'm very sorry. Island, welcome in another member of the channel, Carolyn Lower. Sam, I'm having the same issue with the like button. I don't know what's going on, y'all. I can't help the situation. I don't want to like restart the stream because that's going to jumble up everything. Nicole B, another member of the channel, saying hello, and welcome in. And B saying, hi, everyone. It's late, almost 4 a.m., but I will try to stay for a bit. Another member of the channel, welcome in. Nice to have you back tonight. I know there's weird things happening, so I understand. I understand if you can't stay long. Alexis Carney says, I love blind reactions. This is going to be good. That's on the Hannah Gutierrez read. I did watch Kohberger, but I also watched Kohberger under Emily's reaction. So I don't know if I'll have different reactions because I was listening to Emily. Nicole B says, thank you for the gift memberships. I'm so excited. Yes, welcome to the membership. ZMZ says to Amanda Lang, hey there, familiar name. Phoenix Waller, another member of the channel, says, just be careful of music bits when reviewing Hannah footage. Don't want that strike. At this point, YouTube is taking this video, okay? YouTube is taking this video. It's telling me I only got 3 people in the chat with me. Or maybe I only have 1 person watching right now, but the rate that chats are coming in, I think there's a lot more than 1 person here. MB says, I see the chat is moving, so I think the number of people watching is wrong as people are commenting, yet it only says 1 is watching. Yeah, on your end, you're seeing that as well. It's okay. We're going to figure it out. Carolyn says, no, all good visually and audio. Okay, sounds good. Darlene says, well, don't forget the TikTok sidekick went to court today. I am not caught up on that. I don't even know what's happening in that case. I know Emily has been covering it. So my plan actually when I get off this stream is to watch Emily's so I can figure out what's even going on in that case. Carolyn Lois says, I don't think the number is accurate. No, it's not. It's doing weird things right now. And now I'm getting back up in the stream again. Ohio Palm Mom, another member of the channel, welcome in, saying YouTube is acting crazy. Recovery Addict is covering the Arizona unaliving trial. Okay. I don't know who that is. So welcome Brian and Jill W, likely Jill, welcome into the live stream. Saying me either to Darlene. Let's see. Okay. Amanda Lang says, when YouTube starts gaslighting creators, it is, and it's really gaslighting me, and I just feel like I don't know what to do. I don't know what to do because we can't even hit the like button. Like, this is out of control. And sorry, y'all, I skipped some chats, but I'm like, my brain is all over the place, and I want to do a good live stream, but I'm like, I see like chats coming in. There's no way there's only 2 people watching. MB says YouTube has been having issue for days. Don't do anything, Bree. Everything looks and sound great. Just the viewer count that is messed up. Okay, that's no problem. We're still gonna vibe. We're still gonna have fun. Okay, let me go ahead and jump into the live stream, y'all. I think that I want to start with Bryan Kohberger because it sounds like Hannah Gutierrez Reed's case is going to be very interesting. So we'll hold her off to the end of the stream so we can make sure that the energy stays up because we've already had a crazy start to the live stream. So let's go ahead and jump into Bryan Kohberger. All right, y'all. So if you don't know what's going on with Bryan Kohberger, he is being accused of unaliving 4 college students in Idaho, and they are in Latah County. I think I'm saying that right because it looks like Latah County. But anyways, they are there. But he is facing the unaliving penalty, which is suitable because, 4 people, if he is guilty, because we don't know yet, he has not been found guilty yet by members or a jury of his peers. He has not been found guilty yet, so we can't say that he did the 4 unalivings. I think that the unaliving penalty, if he is guilty, is very fitting for the crime. I know there's some people that are against the unaliving penalty no matter what, and some that are for it. If you are unaliving people, it's like an eye for an eye. Well, his defense attorney, who is, I believe, the only or one of the only attorneys in that state, I think it's the state that can practice these unaliving penalty cases, is saying, well, all fine and dandy that you guys are charging my client. However, this particular county is too prejudicial because so many people already know about the case. So in order to prove that there are too many people that know about this case and that he's not going to have a fair trial because people already think that he is guilty, because that is the case, we need to move this to a different county and potentially a different state. But before we can really decide that, we need to have a survey done to determine whether this should be moved to a different state. Prosecution, it's like fine and dandy. You can go ahead and file that motion. However, the questions that you are using in the survey are prejudicial, and they are violating the non-dissemination order. Remember, in the Kohberger case, the attorneys are not allowed to disseminate information without court approval. So we have the affidavit, we have a couple motions that we have access to, but they are not to be releasing additional facts. In some of these questions, one of the main questions being that Bryan Kohberger was following around, or AKA stalking, a couple of the victims. One of the questions had to do with that, and the prosecution is saying, well, that is false. Why is that one of the questions? The surveyor is going to go on to say it doesn't matter if it's false, it's in the public and people believe it. So we're going to jump in and watch the actual questioning of the surveyor. We're not going to watch the back and forth of whether this needs to go forward, whether we're ready for a change of venue motion. The prosecutor and the defense attorney argued back and forth for quite a while, trying to figure out what to do next with this. So we're going to jump into it, see how everything is going. Let me know if y'all can hear everything all right. We're jumping right into the surveyor giving his opinion about what is going on here. So here we go. Oh, I have to share the screen. Yeah. Okay. I do have to share the screen. That would be helpful for everyone present, right? Okay, here we are. Y'all can see him now. That's the judge. Those is the defense counsel table and the defense and prosecution table. You got Santa Claus over here. You got Ann Taylor over here. You got Bryan Kohberger here in a snazzy suit. And let's go ahead and jump right into it. Let me know if you guys can hear the video, okay?
Okay, Dr. Edelman, if you could please come forward, face the clerk, raise your right hand.
And I'm going to speed it up a little bit because we don't have all night to be here with these folks.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do. All right, thank you, sir. If you could please take your seat there. And then once you're comfortable, please state your name and spell your last.
It's Bryan Edelman.
And they're also going to have a little bit of chatter about showing this PowerPoint because the prosecutor did not receive it until this morning or the morning.
I work as a trial consultant, and also I do quite a bit of work as an expert witness in the field of pretrial publicity and change events.
Are those two separate roles?
Yes, they are.
What do you do when you're a trial consultant?
So as a trial consultant, you're an advocate for your client. You want trials, focus groups, to really try to develop a trial strategy, a trial story for your side, and cultivate that for the audience, the jury. We also do jury selection. I assist with writing voir dire questions, juror questionnaires, help figure out bias during voir dire.
So he's just basically giving his background of why he
post-trial interviews,
qualified to testify.
Jury-related research, present my findings at conferences, bar associations, law firms, and so on.
When you work as an expert in the field of change of venue, does that differ from your work as a trial consultant?
Absolutely.
How so?
Well, as I mentioned, as a trial consultant, you're retained to be an advocate. As an expert, you are retained to be an objective expert, which means I'm not advocating for either side. I do not advocate for the defense. I do not advocate for the prosecution. My role is to collect information using standard methods that have been widely accepted in the field, and then present the findings to the court so they can make a well-informed decision on whether or not any remedial measures are necessary. So there are times where my findings support what remedial measures, like a change of venue, and there are times they don't. And when they don't, I recommend against a change of venue. Whatever the data supports where I go.
I want to understand a little bit about your educational background that allows you to do that work.
Okay.
How were you educated?
I'm sorry.
How were you educated? What degree?
Starting in grammar school.
We can skip to college.
Yeah. So I have a bachelor's degree in psychology from Florida State University. From there, I attended the University of Nevada in Reno, where I studied social psychology. My particular interest was in the application of social psychology in the field of the legal arena. So I was really interested in juror decision-making, jury decision-making, group dynamics,
fast for
how people
y'all, or
process
is
information
this
and
like
evidence, the impact on pretrial publicity, pre-existing attitudes, and that sort of thing. The school I went to really focused on that area. That's where the National Physician College is, the Grant Sawyer Center for Justice Studies, and several professors in that field. So I conducted research at the Grant Sawyer Center for Justice Studies. I helped run a program through the Department of State that brought in judges and attorneys to the United States, where they would travel around the country to meet with people in their field. So I worked with the National Judicial College in that regard as well. And then from there, when I finished my PhD,
And
I got a
unfortunately,
Rotary
they're going
Scholarship
to be
study
showing
in the
us
United
the
Kingdom, where I got
slideshow
an LLM in
throughout his
international humanitarian
questioning, his
During
direct
the course of your
from
career,
the
have you been published?
attorney.
My
Don't know why.
area
There it is.
survey methodology. My research was on the death penalty, so I have a book published on the death penalty. I am the co-editor in California. There's something called the CEB, the Continuing Education of the Bar, and there's a criminal procedure book that comes out every year. It's kind of like the Bible for criminal procedure, and I'm a co-editor on the chapter on change of venue. I was also on the committee for the American Society of Trial Consultants that publishes professional guidelines for writing change of venue surveys. So on that, and I've also done research
Got a little
on
bit better
one of the questions is always, well, why can't
there.
we just pick a jury in a high-profile case? So I've done research on the use of the set-aside question. So if people have been inundated with a lot of prejudicial media coverage, how do they respond to that set-aside question? Do we see, for example, if somebody's been exposed to a lot of prejudicial coverage, you'd expect them to say, I cannot be fair and impartial, I know too much. And so we're looking at research on that as well. And then last thing I promise is, I've also done research on what's called minimization language. So when you ask people an open-ended question on a juror questionnaire or in voir dire, in a high-profile case, this is the only standard question, what have you read, seen, or heard about this case? That's the open-ended question. And people minimize what they know. That's something Dr. Ed Bronson came up with because he had noticed it. And that's like using language such as, I only recall what was in the paper, or I just followed it. I just remember it was on the news. You don't really elicit a lot of information. It's minimized knowledge. So did research on that. So,
That's been part of your research?
yes.
When you work as an expert, if you're hired as an expert to work on a change of view issue, and I think you told us how your work is different than when you're a trial consultant. Can you tell me how you start in that role as an expert for change of venue?
Yeah. So first of all, I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue specifically? Okay. And to do with surveys, just to be clear?
Yes. From some of it's surveys, sometimes it's post-conviction, and once again, I've done federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other powerful ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a three-stage process. So the first phase is collecting the media coverage.
This for
Really
a
the
while
question
and
is,
worked in
initially,
other cases.
is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it, and it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe there are victim impact statements where the victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victims, are focusing on that. So there's a gambit of things that we look at. Sometimes there's political elements that are important in high-profile cases because they might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters.
Hear him saying that a lot. He doesn't care
make a difference
if it's wrong or right.
True or false. They still develop an opinion and an attitude. defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey. And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered blood beer. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of venue.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper.
It's literally like headline.
I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
Well, you've seen the slides.
I have.
You looked
But
at it.
everybody else here hasn't.
How you
What I'm
judge?
seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But we're getting this visual aid. There's no foundation for it, Judge.
Well,
It just seems.
well, hold on. I'm viewing him as an expert.
Yes, sir.
And he's explaining what he does. So I'm going
No
to.
problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
He keeps cutting off the judge. Like, how you think you're gonna get anywhere here?
All right.
I'm sorry.
Yeah.
Frankly, I've never seen
I'll
something like
override
this occur.
that objection. I mean, this is not necessarily factual. It's just an
It's not.
example
It's like
of
headline.
how he got to where he got.
That's his testimony, but the
even minutes,
PowerPoint is different, Judge.
headline.
I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do,
Okay.
Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand him my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have
I
three here.
don't
Let's
even
just.
agree with that. I think it's literally just
Go
headline.
ahead.
Dr. Edelman, we were talking about where you get your information. We were talking about
Definitely.
where you get your information. What media do you look at? I think that's where it was.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but
He's not even
I
listing
wouldn't, for
what
example, look at a
says
newspaper published in
media
Dallas
coverage, and then he
because
explains what
I
media
don't know if somebody in Latah County would be looking at a paper in Dallas. So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic, and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And in January, did you receive an email from my office with the non-dissemination order?
I believe I did.
And you looked at a hard copy again recently?
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you know?
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the
Notice that he's
media got the
focusing
information?
on in the
Yes.
media, not necessarily through the court documents.
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up.
I can't hear.
Kohberger,
Well, I'm gonna do my best to turn this up.
You know what's crazy is like if Kohberger is not the one that did it, they're just letting whoever did
Yeah,
it
you have.
roam free.
If I put the microphone up, is that better?
So Christy, you don't have to type.
Does the chat think Kohberger is guilty or not guilty, or you don't have enough information?
let me preface, there's a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
In that clip, you heard reference to the probable cause affidavit.
Yes,
And did you hear reference to sharing it with all your readers and watchers?
readers, watchers, and listeners, and anyone else who's interested.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes,
Good afternoon, folks.
What did you say?
basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information. So let's be clear, they didn't just read the affidavit. There's editorial, there's debate, there's discussion, there's spin, all of it in news stories. And these stories, for example, this one has over 200, I'm sorry, I can't see it. Do you have a copy of
I
the?
put up a poll in the chat, y'all. Do y'all think Kohberger?
I do, Your Honor, I have a printed copy of his PowerPoint. If it would help him refresh his memory.
I just can't see it.
Sure, just go ahead.
Okay, thank you.
And they're trying to figure out, like, is this being disseminated? I mean, it's public record. So whether they had a
So example,
non-discrimination
this one
order
is
or
on a
not,
local
they
television
would have been
station.
able to see this information.
On YouTube alone,
Easily.
130,000 views and 224 comments. So people discussing. That's just one example of how this document was disseminated through the media in this county, just as Mr. Thompson suggested during his press conference.
And did you check another media source and see that it continued to be shared?
Yes, this is a second example. And you can see just from the heading, it says court records unsealed. And then they go through a timeline, including information from that affidavit, highlighting all the key findings about the car and other things that are widely reported and disseminated from that document. To Latah County, saturating the community with prejudicial details from that document, which was reported in the press
It can
conference
be
to be truthful as well.
prejudicial if it's true.
54,000 views, 176 comments on just
I
one
get
other
it.
video of
But they're
a
saying
news
the information
clip on
has
YouTube.
been disseminated
And based on your
far in
research,
each
did the
county.
story or stories continue to be shared far and wide?
Yes,
Janelle Finch is joining.
cases received massive media coverage, saturating this county with prejudicial pretrial rules.
How about to social media?
It was also spread through social media, and people have talked about it on social media.
And do you know if misinformation and rumors ended up as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this. Other references to questioning the implication of people knew about the crime before it was reported to the police and so on. So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in small communities such as this.
Did your review of
I don't
all
think
of
it's
this
just the
information
community.
tell
This
you
is
as a
like a
professional, as an
national
expert
thing
in your
at this
field,
point.
that a survey was necessary in Bryan Kohberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
We always use random digit dial telephone surveys in these cases.
Before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design and focus on case-specific items was done in 1979. Constantini and King in 3 cases in Yolo County, California. This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, had been using it for decades, 40 years or more. Other experts in the field do it. John Walker, in the American Taliban case, they used a similar approach that was published as well. Used in Skilling, Boston Marathon. I've used it in countless cases, so hundreds of times, I would say.
Is there research that supports this process?
There is.
Yeah.
One of the things we're looking at, so when you think about the survey, is the structure and how we test validity. So there's 40 plus years of social science literature on the impact of media coverage on jury decision making. And one of the things it tells us, for example, is knowledge, or take a step back. People who regularly watch and listen to the news are more likely to know about the case. When I say know about the case, are more likely to have case-specific information from the media. So they test similar things like we did. Have you read, seen, or heard if ... And they assess how much knowledge does this person have, and then they correlate it with media consumption habits. And what you find is people that read the news regularly know more of these details than people who do not. And they find that the more information you have, the more likely you are to hold an opinion regarding the defendant's guilt or innocence. So those are some of the findings, and we
I
craft
can
the
agree
survey
with that. You're
similar
already
to the others
developing
because we want to
opinions
test the
before.
validity of the survey. So if we know we should see these relationships, we should expect to see them in our survey. So we ask the same similar types of questions, and we look at those relationships to see if we see the same thing. That's one of the ways we test the validity of survey.
Would this be considered a methodology in your field to do surveys in this certain format?
Yes, it's standard practice. We look at APOR, which is called the American Association of Public Opinion Research, American Society of Trial Consultants. They have professional code, how to conduct surveys, venue surveys. Those are the primary ones I look at. And again, I've taken course training during my program on how to craft surveys, how to write questions, all of that type of thing. I've done it hundreds of times, testified about it. So that's kind of the basis of how I practice.
And I heard you mention standards and validity.
Mm-hmm.
Why are there standards? Why does that matter?
I'm sorry, why are there standards?
Yes.
Well, one is you want to make sure, as we learn more about research and human behavior, we learn more about what you should and shouldn't do. So for example, there's something called social desirability. People want to create a positive impression of themselves. So when you ask questions, for example, can you be a fair juror? Well, we all want to be fair people, so you're more likely to get a socially desirable response. The initial step on that was all the way back into voting. In California, there was an election for governor in Davis or something like that. And all of the polling suggested he was going to win. He was African American, and he lost. And that was when they started looking at that. And they saw all these different impacts in terms of like race of the interviewer. All these things affect how people respond. People overestimate that they vote because you can look at voting records and it's inflated. People overestimate they have a library card and a million other things. So those are things like we look at when we craft the survey. We don't want to have social questions that lead to socially desirable responses, order effects, a host of other things.
In your survey, it looks like you have sections designed in your survey.
Mm-hmm.
Sorry, can you hear me? Okay.
Better with the microphone.
Okay, I'll try to stand closer over here. I want to understand this section, these sections. Why do you have sections in this survey?
Sections?
Yes.
Well, one is you don't want things to be jumping back and forth all over the place because it's harder to take a survey like that. You'll have more people drop off, confusion, potential order effects. So we try to organize the survey into sections. So all the key questions in one topic are together, and then the next section changes topic, so it's easy to follow.
What is the purpose of section 3, case awareness and prejudgment? Why is that in there?
So that's the meat of the survey. That's the most important section. So case awareness measures initially case recognition. We craft a recognition question based off of the media coverage. What are the things widely reported that are not overly prejudicial because you don't want to create an order that would stimulate a memory of, yes, I remember that case. So if widely reported A, B, and C facts that you read the coverage and you see this was mentioned 100 times, that's a widely reported fact. So we create case recognition question. Now, if somebody says, yes, I remember that case, I have read, seen, or heard about it, they're asked a prejudgment question next, guilt or innocence question. Then they're asked open-ended questions and then those case-specific items. Now, let's say someone does not remember the case based on their case recognition question. We give them one more fact to see if it'll stimulate a memory. Something neutral that might stimulate a memory. You usually get 1 to 2% more of that recall the case from that. If that person recognizes the case from there, they are also asked that prejudgment question to be considered. If they do not recognize the case, they skip the rest of the survey and they're asked demographic questions about media consumption habits and demographics. The next step of the survey after the prejudgment question is an open-ended question. What have you read, seen, or heard about the case? There might be a few others we had based off of these things we might find in the media coverage. And then they continue on to those case-specific items that we've been talking about. Have you read, seen, or heard if so and so?
I want to make sure I understand this and that this is clear for everybody. Those 9 questions that have been the problem last week and this week, if you have somebody who says, no, I don't know that case, do you ask them those 9 questions?
No, they skip to the demographic questions.
Tell me, what are the demographic questions, just to be sure?
If somebody doesn't recognize the case, they immediately go to questions, for example, how often do you read the newspaper? Every day, several times a week, rarely, never, something like that. And they're asked how often they follow the local news. And then they'll ask a few demographic questions like age, gender, race, ethnicity.
So if somebody doesn't remember the case, you don't infuse information or do any of the things that were brought out last week.
No.
Are y'all getting like
I
that
have on the screen in front of me some of the
video
read,
game
seen, or
sound?
heard questions.
Yes.
What are these? You don't have to read them all, just tell me what they are.
These are 9 items, which we always use. Have you read, seen, or heard if? And these are items taken from the media coverage that were widely reported. And let me be clear, widely reported hundreds and thousands of times, and potentially prejudicial items, because neutral run-of-the-mill media coverage is often not grounds for a change of venue. So if somebody knew there were 4 victims, that's not particularly prejudicial, is it? That's pretty benign fact. But if somebody knows, for example, about a prior conviction that's not admissible, that's very prejudicial, and it might be correlated with prejudgment. And I would like to know that, because if it's widely prejudicial and everybody knows about it, and it's correlated with prejudgment, that would likely have an impact on my recommendations, because that's the type of pretrial publicity that has been recognized by the Supreme Court, for the state court here, that is most concerning.
So these kinds of questions, these case-specific questions, you do this in all the surveys that you do.
Yes.
And in this case, these 9 questions came straight out of the media.
Absolutely. And again, widely reported throughout the media, thousands of times.
Now, just to be clear, you gave an example of information that might be widely reported that's highly prejudicial that you would use in a survey. You haven't talked about Bryan Kohberger's survey yet, have you? You haven't told us the 9 questions.
I have not.
Okay. And we'll get there, but I want to talk about a little bit more about the history of this survey. You told us it had been used for decades, and I think you told us a little bit about some of the other really high-profile cases where this survey format, the survey method that's been widely accepted, was used. Are some of these cases your cases that you've done these surveys in on this list?
Yes, I used these types of questions in the George Floyd case for Alexander King, who was one of the defendants. There was also a gag order or non-dissemination order in that case. The Parkland shooting case in Florida, there was a non-dissemination order in that case. Used there as well. Used it in the Pittsburgh synagogue shooting case in Pittsburgh. State of Idaho v. Jonathan Renfro, which was here. State of Idaho v. Gilberto Rodriguez, also used it there. And many others. I've used it 100 times. Dr. Bronson used it more than me because he was doing it even longer than I have.
Okay, so a lot of people are saying that they cannot hear me when I talk while the video is going. I'm trying to like mix and match and make sure that y'all can hear me. But just to make sure that everybody is following along, he's basically trying to defend his methodology, which he says is an industry standard, and he's the expert, so he would be the one able to testify to that. Now, if the prosecution did not agree that this is the methodology, then they could have brought their own expert to say, no, he did this wrong. So he's basically saying in all of these famous trials, he has used the same or has seen this methodology used in asking these questions where they're asking kind of fact-specific questions to the case, and then they go on to like demographic information. But if they say they never heard of this case, if you say, oh, have you heard of the Bryan Kohberger case? Some people might say, I never heard of that. But if you say like, I've heard of Idaho 4 case, then someone might say, oh, well, I know that one Kohberger guy is the one being charged, right? And then they'll go on into those fact-intensive questions or specific questions for the case. So he's basically saying that everyone that does the survey is not exposed to all of the fact questions if they say they don't know anything going on with the case, or they haven't heard anything going on with this case, or they don't remember the case. So I'm going to let them talk a little bit more. And once the defense is over, we'll get into y'all chat. So if y'all have opinions, make sure you are dropping it in the chat so that we can discuss it once the defense is gone. And if you haven't already, go ahead and vote in the chat whether you think that Bryan Kohberger is guilty, or if you need more information, or do you think they got the wrong guy? Is the right guy running around town, running around the college campus waiting to do this again, or did he go and move to a different country? So go ahead and vote in the chat or the poll if you think that he's guilty, not guilty, or you just need more information to come forward. So exactly what they're asking us not to do through this survey, I'm asking you to do it here on the Bree Hive. So let's go ahead and jump back into it.
Other experts in the field do it. This is the standard practice.
standard in your field.
Yes.
And are these surveys, doing a survey like this, is this just criminal defendants that ask you to do these surveys or that have any interest in doing these surveys, or is it other people too?
Other people use the same process as well, including the prosecution and the government.
I think you provided an example in your PowerPoint of the government using this survey process in a case that you worked on.
Yes, this was a Jason Van Dyke case in Chicago. He had been charged with shooting and killing Laquan McDonald. It was like 17 shots was like the famous saying. It was a very significant case, interracial crime, widely reported on. And the government also did their own survey to see if there was any potential bias and followed the same exact process and used case-specific media items. And once again, there was a non-dissemination order in that case.
Earlier, you talked a little bit about validity being one of the standards.
Yes.
Tell me how you measure validity in one of these surveys.
Sure. So this is from the professional code from the American Society of Trial Consultants. As I mentioned, we want to look at things like consistency. So we want to, for example, the research tells us the more case or media items you know, you develop knowledge, and the more you know, the more likely you are to exhibit bias. So I want to test that in the survey. That's one of the reasons why I include those case-specific items. I also want to compare what people or that item to prejudgment. So the more people know, are they more likely to prejudge? How about case-specific media items? Is there specific prejudicial items in the media that are particularly concerning? Maybe I'm going to go back to my prior conviction example. If there was a conviction, so had this happen in the case, and then years later, that conviction was thrown out and there's a new trial. Well, that's extremely prejudicial if people know about the prior jury verdict. So I want to know, what percentage of people know that detail? And is that related to prejudgment? And most importantly, when you ask the question, have you read, seen, or heard about the case? The open-ended question, do people report it? Because if they don't, and they do know it, well, that's very concerning. And that's the type of problem we run into in voir dire.
Sounds like that's one of the reasons you have case-specific questions in there.
That is one of the reasons, one of the issues you run into during voir dire. Because someone be like, yeah, I have no idea about this case, because they do want to be on the jury. So that is something to watch out for as well.
That's one of the reasons, absolutely.
You heard talk last week, and then you heard it again today about, can't you just change the survey and take those case-specific questions out and then do the survey? Can you do that?
I would not do that, no.
Can you explain why not?
Because this is based off of 15 years of doing this. I know for certain, and there's research on it as well, that
He's starting to get annoyed now. Why you keep asking me the same questions, girl?
when you ask people an open-ended question, what have you read, seen, or heard about the case? They have a difficult time recalling everything from memory. That's a recall question. The cognitive effort required to recall everything from memory that you know is very challenging versus recognition, which is a much lower cognitive load. Have you read, seen, or heard if? Oh, now I can search my memory. Yes, I know that fact. If I asked you, tell me everything you know about the movie Star Wars, you would tell me a whole bunch of interesting things about Chewbacca and Ewoks, and maybe a bunch of other stuff. But I am very confident that you would miss things. You would not tell me every single detail from memory you know about that movie. And then I would ask you something like, did you know that Darth Vader was Luke Skywalker's father? And you'd probably say, yeah, of course, I knew that. But you didn't mention it in a recall question. There's a mountain of research on this. Usually what they do is they have people read like a paragraph or a story, and they ask them, write down everything you recall from what you just read. And then they do a different type of quiz. Did you read that the truck was red? Did you read that there was an ambulance? Oh yeah, of course. And they check that too. And what it shows is recognition rates, the ability to recall information when asked a closed-ended question, is much higher than when you ask an open-ended question. So getting back to your comment or question, if I only ask, well, what do you know about this case? I know for a fact you'll get things like, well, I remember when it happened. There were 4 victims. There was a knife. I remember there's a delay. I just saw it in the media. Those are the things that people say. They've said it in this survey. They've said it in 100 surveys I've done prior. They've said it in voir dire when I look at transcripts. That's what you see. But when you ask those closed-ended questions, you discover that they know quite a bit more. And that's what I'm trying to look at. I need to know, what do people actually know? And is there information, prejudicial details that they don't mention that they do know when you ask the open-ended question?
And those details, the closed questions, the have you read, seen, or heard questions, are they important to determine if there's bias, that media coverage has created a prejudicial effect and that there's bias?
Absolutely. If 80% of people are able to recognize a prejudicial detail, and I keep making up because I don't want to upset anyone here, like a prior.
Well, yeah, we recognize the prejudicial details because that's what stands out. When you say that someone for lack of a better example, the question they try to ignore a lot here is that he stalked them. It's like, okay, that makes sense that he then would break into their house and unalive them, right? So yes, prejudicial things do stand out. The fact that your car matched the car driving by in the middle of the night, that does stand out. The fact that your phone was turned off specifically during that time and it was found at your apartment and then in a random place, and you having this criminal background as far as studies, all of that stuff stands out. Does that mean that a jury cannot be unbiased? I would say no, it doesn't necessarily mean that. So no, I definitely get where the expert is coming from. I think that there could have been some deeper
convictions. If 80% know that detail, but only 3% mention it in the question, what have you read, seen, or heard about the case? That's a major problem. I need to know that because it's an extremely prejudicial fact. Things spread on social media, whether they're true or not, they still impact the jury. Very prejudicial. I need to know if they know that. And I know for a fact in this case that, for example, I'm not going to mention the detail, but for one of them, only 3% of people in the survey mentioned the detail when asked, what have you read, seen, or heard about this case? It was something spread on social media. But when you asked, have you read, seen, or heard of X, Y, and Z, 45% knew that fact. And that fact happened to be significantly related to prejudgment. People who knew it, over 80% of them think the defendant is guilty compared to 57% who don't know the detail. So those are important findings. If I don't include those questions, I can't do any of those analyses. It makes it look like there's not that much of a problem here. People don't seem to know anything. They just say they remember reading it in the paper. I guess we don't have to move the case because they don't seem to know much. And that is misleading, inaccurate, and I would not do that.
Have you had a unique opportunity to kind of actually watch this in real time to see how it works?
I have.
Can you tell us about that?
Yeah.
How did you get this unique opportunity first?
So I worked on a case that was called John Fight. This was a Catholic priest in Latah County in Texas who had been charged with murdering a beauty queen. Now, the crime had happened in like the 1950s, and the trial happened in like 2018 or something like that. So all the witnesses were gone, and the defendant was obviously much older. But it was a case that was just weaved in the fabric of the community. So shocking. And during the hearing, after doing the survey, one of the things we did is we brought in community residents and did like a mock voir dire to prove this point, to demonstrate. And there was a bunch of things in that case that were particularly prejudicial. So we asked people, tell us what you've read, seen, or heard about the case. And they would tell us, oh, in college, I learned about this case. So I know A, B, and C. And we say, is that everything you remember? And they said, for example, here, I believe so. That's what this person said. Search their memory. Let's see. I believe so. That's it. And then we asked those case-specific questions that you clearly could never ask in voir dire because you'd be poisoning a well. And we asked, for example, did you know that John Fight gave a confession to a priest? Confessed to the crime. Oh, yeah, I knew that. And once she said that, it stimulated memory. Actually, he confessed twice. So now she knows that. The fact that she did not mention in the
My question would be like, if you phrase a question like that, would be more likely to be like, oh yeah, I remember hearing something about that. Oh yeah, I remember hearing something about that. Oh yeah, I remember his car matched the car that was driving by on the video. But if you forgot it until you said it, maybe they wouldn't remember it. So I don't necessarily like how those questions are worded, to tell you the truth. Like, did you know that he also did this? It's like, are you telling me that he did that? Or like, no, I didn't hear that. Should I have heard that? I don't know. I don't like how some of the questions are phrased. I feel like they could, you know how you can give like a false confession. And I feel like some of these questions could lead to a false confession, in my opinion, but I could be wrong.
The open-ended question, extremely prejudicial. The Supreme Court has recognized confessions to be very prejudicial for Doe v. Louisiana, a bunch of others, and she knows that. And then we asked, kind of again, is that everything you know? And she says yes, and then we give her another one. Did you know that he was involved in another case? He had actually been charged with attacking a woman in a different church. Oh yeah, yes, I do remember that. Once again, she knows a detail that she didn't mention. And Redford said, okay, and you didn't say that a few minutes ago. Did you? No, that's the second one. And then we asked, have you refreshed your memory? Are there any other facts that you have read, seen, or heard that you haven't told the court? She's, I don't believe so. It seems like that's all she knows. Then we tried again, and we mentioned that he had been transferred to another monastery. The Catholic Church was moving him around. She knows that too. Oh yeah, I did that. We tried again. Did you know that local law enforcement were participating in a cover-up? That was part of the story. Yeah, she knows that too. So this was an example of the difference between asking the open-ended question that you can ask in voir dire, what do you know about this case? What have you heard about this case? And you get an answer. Sometimes people say, I just recall when it happened. Sometimes you get more detail. But when you start asking those closed-ended questions, you uncover that actually they know quite a bit more. And that is the key point in a high-profile case. In the general case, it doesn't matter because there's no case-specific information. what we know is that specific attitudes predict behavior much more than general attitudes. So a community like this has been saturated with media coverage that's prejudicial. We want to know what case-specific details they know, because that goes to bias, and are we able to ferret out that bias in jury selection? And that's why we include those questions in our survey.
I want to talk about Bryan Kohberger's case for just a minute.
Your Honor, again, I'm going to register the objection. This is going to deal with the actual issue of change of venue. It's premature. The state has not been afforded the opportunity to analyze much less respond to it. So to the extent the court wishes to allow this to continue, I just simply ask you to give it that reduced amount of weight, because the state is not in a position to respond to any of this.
Okay, thank you. But you'll have an opportunity to respond to any of this or any of the decision.
Not today, Judge. This goes. I'm sorry.
Hold on. It's not going to make a decision today.
Yes, sir.
I'm getting information,
Yes, sir.
and then I'm going to consider what you're going to provide, and then I'm going to make a decision.
My point again, Your Honor, is this goes to the issue of a change of venue, not whether or not the non-disclosure order was violated and what we should do about that. Two separate issues. The state is not prepared and will not be prepared to address a change of venue issue until an appropriate motion with supporting documentation and evidence provided, and we have a chance to respond to that, which I understand we'll be doing between now and sometime next month.
Exactly.
Thank you.
Go ahead.
Thank you. Dr. Edelman.
Why does it keep doing that little bling bling? Is that like something in the recording, or somebody recorded this on their phone? Like, I don't know why we keep getting the text message sound, but let's go on.
Or you haven't finished analyzing the data in Mr. Kohberger's case, have you?
No, the only thing I looked at was supposed to be on the question at hand, which is about these case-specific items, why they're in the survey, and which goes to whether we can continue the survey without them. That's the only thing I looked at, was addressing that specific question.
I'm not going to ask you what your opinion on change of venue is today.
I don't have it. Well, I do, but I'm not done analyzing the data.
I want you to be informed before we get there. So I do want to talk, though, about Bryan Kohberger's case, and if you've been able to determine if the survey was valid.
Yes, absolutely.
And how did you determine that the survey is valid?
Well, one of the things, as I mentioned, is looking at the social science research, and do we find similar findings? And we did. So we also look, for example, do we have like acquiescence bias? What that means is people just saying yes to everything. So on those case-specific media items, one of the things you do is you include items that didn't receive as much media attention. That way, you want to make sure, and what you expect to see are items that get a lot of media attention. Everybody knows about, so you see really high recognition rates, 80%, 90%, 60%. And then the items that didn't get as much attention, they're lower, 40% or less. So we want to see if there's variance across the questions, and we see that as well.
Does it help to do the recall questions and the recognition questions to understand whether you have a valid survey? Is that what you're telling me?
Yeah, well, as I mentioned, those are the case-specific questions. Yeah, those media items. So we test validity by, are those correlated with prejudgment? Are they correlated with media consumption? So people who read more of the media, do they know more of these details than people who don't? The more details you know, are you more likely to be biased? All that stuff. But also, again, like I said, is you want to check to make sure there's variance across those media items, because you want to make sure people aren't just saying yes to everything.
You talked early on about how if somebody doesn't recognize a case, you stop and you don't ask these case-specific media generated items.
That's correct. And remember, these media items also come after the open-ended, what have you seen or heard about the case?
Do you know how many people did not know about Bryan Kohberger's case in this survey, the percentage?
I believe it was like 3 to 4%.
And so that percentage of people didn't get the case-specific questions. Is that fair?
The people who did not know about the case, the very few, did not get the case-specific questions.
I want to talk about the open-ended questions and then the have you read, seen, or heard questions. So on the open-ended questions, when you say, what do you know about this case? Tell me everything. Do you know about how many things people remember?
Yes. So one of the things we do is we read everyone and we track how many details they mentioned. And then we compare those, what do they say, to how many case-specific items they later recognize. So for example, if somebody said, I know 4 people were killed and they found the guy, I would identify like 2 facts, 2 details, for example. And then I would look at those case-specific items later and how many of those items did he mention in the open? And that scenario would be 0. But if he knew 6 of them, that would tell me that he knew 6 details that he failed to recognize. Versus somebody might have known all those details and mentioned all of them in their open, then it would be 0. They reported everything they knew, and they mentioned later on that they knew those items. So I look at that.
You're checking what they say they know in the general open question, and then see if they hit some of the specific questions and then measuring how many more they actually know when you get to the have you read, seen, or heard question.
And then I compare. And that kind of goes to my John Fight story, looking to see if that is a problem.
What did you find in this case?
I found that 96% of survey respondents knew at least one additional media item that they failed to mention in the open-ended question. On average, people reported 1.6 details when asked the question, what have you read, seen, or heard about the case? However, on average, they later recognized 6 out of the 9 media items, and I believe it's something like 72% knew, I want to say 5 or more.
Now, in this situation, did you find out people had a lot of knowledge that wasn't the specific case related questions? They would rattle off, I know these things, several things.
Yeah, so what I found was on average, people knew at 4.9 additional items that they failed to mention in the open. What does that mean? That means they knew approximately 5 of the media items that I tested later that they did not mention in the open-ended. 5 on average out of 9, they knew, although they didn't mention it. And these are examples. So somebody wrote just what has been on the TV and papers. That's the common thing you get when you only ask the open-ended question. But that person knew all 9 of the media items we tested. Someone else mentioned the detail. The kids were murdered and they tracked them down. Well, you actually know 6 out of the 9 media items that we tested. Nothing lately. Knows 7 out of the 9 media items tested. And it goes on and on. That is a very common finding. I find it in almost every survey I do. Between 92 and 96% is the norm. What I see in terms of knowing more detail than they report. And usually, interestingly, the average is usually around 3 extra media items that they failed to mention. In this case, it was 4.9, so it's higher.
Do you have a way within the survey to correlate prejudicial coverage or bias for guilt with the amount of specific details recognized?
Yes, because I asked those case-specific questions. If I didn't, I would not be able to. Because as you saw, people say things like, haven't seen anything lately. Well, that doesn't really do much for me. I can't analyze that. I can't do anything with that. I don't ask those case-specific items. I can't test the validity of the survey. I can't test to see how case-specific knowledge impacts prejudgment. I can't test to see if there's one particular item that's highly prejudicial that we should be worried about, that should, that's inadmissible. What percentage knows that detail? All of those things are required to do is correct.
And how do you know that there's prejudgment in a case? What questions do you ask, and when do you ask them to know that there's prejudgment or bias in a case?
Well, after the case recognition question, they're asked, based off of what you've read, seen, or heard about this case, do you believe the defendant's guilty of whatever the crime is? And it's on scale, like definitely guilty to definitely not guilty. So that's a prejudgment question. I have a second follow-up question, which was actually developed from a judge that I thought was really effective. And the question was, would the defendant have a difficult time convincing you that he's not guilty? So it's a presumption of guilt as opposed to a presumption of innocence. This was in Tennessee. It was a high-profile case, and similarly, people would report a lot of detail, and then they'd say, "I think he's guilty," and then they'd ask, "Well, can you be fair and impartial?" And they go, "Yeah, I think I could be fair. I can try. I think I can do it." And then the court would ask, "Well, would the defendant have a difficult time convincing you that he's not guilty?" And they'd say, "Oh, yeah, definitely. It could be hard to change my mind." So I use that question because I thought it was really effective, and it happens to correlate much better than the set-aside question with prejudgment and a host of other things.
So do you ask those questions before you say, have you read, seen, or heard these particular?
Absolutely. If you didn't, you'd be creating order. So you have to do that.
Will you say that again? You'd be creating what?
Order effects. If I put in like a recognition question, some detail that's extraordinarily prejudicial, I'll go back to my prior conviction thing for the same crime. And then you say, "Oh, do you think he's guilty?" Well, you just told me a jury convicted. Of course I think he's guilty. So if you included all those 9 items, and then you ask somebody, "Do you think he's guilty?" You just gave them all this information that's prejudicial. So yes, that would be an order. So you would never do that.
So you ask them well ahead of case-specific questions. They have to recognize the case. They have to agree, I know of this case. And then you ask if they already have an idea of what they think of whether Mr. Kohberger is guilty or not in our case.
Correct.
And then you have the case recognition, and you can measure the bias or the prejudicial effect of the media with the incidence of those questions.
What I look at is the prejudgment question, right? That's on a scale, so Likert scale. And then I can look at things like, is a relationship between the number of details somebody knows and the strength of opinion? Definitely guilty, for example, if you know a lot of detail. I can look at case-specific items, media items. If you knew about X, is that correlated with prejudgment or bias? So something that, and so on and on. So that's how we look at the relationship between prejudgment and these different factors.
Were you able to determine if case knowledge was impacting bias in Bryan Kohberger's case?
Yes. So because we asked these questions, what we found is that one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're like undermining his due process rights, everybody knows all this stuff. It's very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought he was guilty. And the average was 6.2. So the average number of these details people already know, 6.2.
Given specific case-related bits of information, these 9 have you read, seen, or heard questions, does recognizing one of those questions, if that's oh yeah, I know that one, does that change?
My bad, y'all. It kind of stopped on us for whatever reason. They did not have the full recording on that one. So we're going to try to figure out where the rest of where you know is all on the screen. We're going to try to find the rest of that video. We don't know why it cut off right there. But either way it goes, he's basically trying to explain that if you ask the open-ended question, people don't really give you all the details because it's probably not at the top of your mind. So we're going to go through the chat. I know some people are not all the way in agreement with the things that I have said. So we're going to talk about it through the chat. If you haven't already voted in the poll on YouTube, if you are live, there is a poll in the chat where you can vote whether you think that Bryan Kohberger is guilty. We need more information, or he's not guilty. The other guy is just running around still. Maybe he had a partner, whatever it may be. Go ahead and vote in the poll, and we're going to get to it maybe at the end of the chat, but we kind of got a lot of chats to go through. So let's go ahead and see what the chat is saying. We need Bossy the Bee to bring us into chat. Okay, Mary Malarkey says to Tanya D, hopefully the early viewers do a refresh and hit the like to help reach Bree's goal tonight. Yes, we are at a goal of 75 likes during the live of the live stream. Let's see where we are. We are currently at 48 likes, which is a lot closer than what we were. We had a rough start with the YouTube not counting how many viewers were here and all of the things. So if you haven't hit the like button, please do hit the like button to help us out in the algorithm and get more friends and help us reach our like goal. We got Kimmy Locker saying YouTube needs to get its act together because I've got strong opinions tonight. Well, all the chats were still coming through. We got American Princess saying the Idaho case is never a dull moment, and it just keeps going and going and going. Sentient Dreamer says this is interesting as far as the questioning of the surveyor. Alexis Carney says, so I don't think the media coverage or jury is more or less prejudicial on this case than any other case. And that's what I'm saying. I think this is a national case, whether it was in Latah County or if it was in LA County. I think it will have the same amount of prejudicial effect. There's a lot of people covering the case. There's a lot of media coverage. What case did we just talk about? I forget the guy's name. Joseph Gatt, of how everybody covered the fact that he was arrested for these things, but only one outlet covered when he got released for the charges that they brought against him, right? So is it going to help him or hurt him if he goes to a different county? He may go to a different county where there are even stronger opinions about the situation, because I mean, not everybody heard about the case, but everybody heard about the case, right? Whether you want to believe it or not, that, oh, it's just Latah County and it was people in their college, so they're going to be a little bit more biased. Everyone is biased on this case. I'm sorry. People have heard about this. A lot of people have heard about this case. Ohio Palm Mom says Santa's mad. Santa is a little feisty today. Kimmy Locker says big mad. He is. Kimmy Locker says, I think the prosecutor objected to the PowerPoint because he didn't want the next slide source of information shown. I completely missed this chat when it came up, so I don't know exactly. Oh, the video of the whoever he was saying that we're going to get you guys the correct information so you can share it with everybody. Well, it's public record. So even if they didn't make that announcement, guess who would have been on there showing it to everybody? We got all the lawyers on YouTube would have been finding that document and showing it to everybody, whether they gave us permission or not. As soon as the document becomes public, YouTubers, media coverage people, they are going to cover the document, whether they like it or not. Phoenix Waller says prosecutor is kind of off base here. This isn't evidence. It's an explanation of what the witness does. And to me, I felt like it was more headlines. It was just kind of like pointers. Okay, this is 95%. Okay, what media outlet did we cover? And then he listed the outlets, but it was not listed on the PowerPoint. So I agree with you. Cynthia Dreamer says, Bree, why is there an objection to the slide? It makes no sense. He's claiming that everyone in the courtroom hasn't seen it because when the judge said, oh, well, you've seen it. And honestly, he didn't really make an objection. He said, this is inappropriate, Your Honor. So I can't tell you exactly what his objection was other than like what Kimmy said. They didn't want to show like all the numbers of people that watch the videos and the people of the government telling us to spread all the news, right? Spread the correct information. So probably because he didn't want those videos shown, but other than that, all he said it was inappropriate. That's not a valid objection. So there's that. Lola Waterton says to Cynthia Dreamer, they call out the prosecutor personally in the slides. I think that's more towards the end, if I'm not mistaken, that we haven't gotten into yet. Cynthia Dreamer says, isn't the prosecutor the one making the objection? Yes, the prosecutor is making the objection. Defense is the one showing the slides. Kimmy Locker says to Cynthia Dreamer, yes, the expert calls out the prosecutor in the PowerPoint. I think that's later on. We didn't get to that part yet. MZ says prosecutor's petty excuse when what he's really objecting to is having his photo and likeness shown and broadcast, as Runkle pointed out last week. LOL. Right? Kimmy Locker says the prosecutor not just shown. The expert throws hella shade by essentially blaming him and his press conference about the probable cause affidavit for the misinformation being spread. Oh, was that him? I didn't even notice that to be him. Isn't that crazy? I didn't even notice that was him. Maybe I should pay attention more. Ohio Palm Mom says, I think the whole non-dissemination thing is a red herring because Santa doesn't want to move the trial. He claims he doesn't mind a survey, but goes after the expert for doing his job. I agree with you. He wants to keep the case. He wants to be the one to prosecute the case. He doesn't want to go into a different county. So, and I don't think that they will transfer him to the different county to handle the case. I don't know. I don't know how that works. But yeah, he wants to keep the case there. I don't know if any other county would be less prejudicial than, I mean, this is a national case. This is not just if it was just only everybody in Latah County knew about it, sure. But everybody not everybody who's anybody, but a lot of people know about this case, even if it's not within the same state. But maybe you'll get a smaller pool that wouldn't know about the case. Darlene says, but they are not facts. They are allegations. Exactly. They are allegations. Cheryl Reed says, although the allegations are pretty strong, still need proof. Agreed. I think you're referring to my poll that went up. Cheryl Reed says the sidekick has wreaked havoc on the professor's life. Serious damage. I don't know anything about the sidekick case, so I can't comment much on that. American Princess says, it's good to know someone else takes on this hearing. We are here. We are watching. We are trying to figure it out. Cynthia Dreamer says, listening to the expert makes the prosecution sound more petty than discerning. Yeah, I agree. I think the questions, I don't like the way that they're asked, but I'm not in charge of this. Darlene says there's a fine line between telling everyone everything and not prejudicing everyone. Agreed. Chelsea B says the craziest thing to me here is that people answer their phones to unknown numbers and answers questions. And that's another relevant thing to talk about. You first are limiting yourself to one, people that answer the random phone calls. Two, you're limiting people to people that are willing to answer your questions. And three, you're probably talking to a lot of people that are interested in the case, because when you say, oh, I would like to ask you questions about cases, and you go, oh, what case? Bryan Kohberger. Oh, I got a lot of opinions on that. Versus maybe someone that didn't answer the phone, or maybe someone that said, get off my line, that don't know much about the case and they didn't answer questions. So, yes, I agree with Chelsea B with the answering the random phone calls, but also maybe some of the people that were not willing to talk to you didn't know things about the case. So is the survey pool kind of skewed there? I don't know. What do you guys think? Chelsea B says to Phoenix Waller, I'm not answering unless I know you, let alone let you ask me questions about a murder. Right. Really, though. Carolyn Lower says, not blaming you. I feel like it is unfair to decide if he's guilty when we only hear things from the prosecutor where the defense has no chance to speak. And y'all, we are just doing our own survey here, trying to figure out, is the information that we have already heard on YouTube in the media, is that skewing our opinions on whether he's guilty or not? Luckily, probably none of us are going to be on the trial, but I would like to see if there are already some opinions regarding Bryan Kohberger's guilt. Amanda Lang says, sometimes you just don't remember until something specific is brought up. That prompts memory too. I agree with that for sure. Amanda Lang says, yeah, but you want to know if they know and if it's prejudicial, not just if they remember it. You want to figure out how to weed out people that might remember in the middle of trial. That is true, but you can't really do that. It's like impossible to do. Unless it's like a smaller case that no one knows about. This case is nationwide. Everybody's reporting on it. So even if you don't remember a specific detail and something comes up in trial, what if something comes up in trial and it's the complete opposite of what was in the media? Are you going to remember something that you heard a year and a half ago, 2 years ago? Or are you going to remember what was said in the trial? So I think it's like what I've seen in the comments, a double-edged sword, to tell you the truth. Amanda Lang says, the expert said he also checks to see what their opinions are so that they can gauge which news items are more likely to be prejudicial. Yes, I agree with that. Amanda Lang says, yeah, Bree, but do you want people remembering in the middle of trial something that was perhaps untrue or inadmissible? And the thing is, you can't get rid of that, even if they move it to a different county. That's why they even tell jurors that may not have known about the case, don't look up more things. And how easy is it for them to avoid hearing things in the media? I know the judge told me not to listen to things in the media, but if YouTube just happens to be playing in my wife's room and I overhear it, so you can't really control that. I get the point of trying to control it, but you can't. You absolutely cannot. It's just like you get people, they'll ask questions. Do you think that you can be unbiased? Everyone's going to say yes if they want to sit on the jury. Yes, I can be unbiased, when they really can't. So you really can't, you can't weed these things out. Mary Malarkey says, I'm seeing 44 likes. We're on our way to Bree's goal of 75 tonight. Let's go. Dropping the B emoji. Yes, let's see where we're at, actually. We were at 48. We're at 52. So if you haven't hit the like button, we got, how many is that? 23 more likes to go to hit our goal tonight. Sentient Dreamer says, these questions are a double-edged sword. I agree with that. Weird Pisces says, I thought the dings were my laptop the whole time. Haha. It was really bothering me. Like, it was driving me crazy. Amanda Lang says, also, it's super unlikely that anyone who receives the survey will end up on a jury. They surveyed 1% of the district or something. Yeah, 1% of the people that could actually answer the questions, right? 18 and over. Kimmy Locker says to Amanda Lang, yep, they surveyed 400 people and the county has a population of around 40,000. And like I said, it could have been people that just weren't willing, those people were interested in the case, so they wanted to answer the question. So there's that. Carolyn Lower says, because that's the way it's always been done is a terrible argument. I agree with that. And the other thing with the questions is if someone's straight up asking you, oh, do you remember that this happened? And you don't necessarily, and that's why I say I have a problem with the way that the words are written. Although you may have never heard of that fact. Sometimes you guys do it to me in the chat and I'll go, oh, I think I remember that. I probably didn't remember that. It just sounds like it's right? I'm sure a lot of people did that during the survey too. It's like, that sounds right, I guess. Kimmy Locker says to Carolyn Lower, I agree that's a terrible argument, but that's not how I interpreted his answer. I thought he was just saying that is and has been the industry standard. It can go both ways. Carolyn Lower says to Kimmy Locker, I guess with how huffy he got when he said that just rubbed me the wrong way. Makes sense. Kimmy says that's totally fair. He definitely came in with a chip on his shoulder over the prosecutor's statement in the last hearing. I agree with that. He was not happy with the prosecutor, and the prosecutor did not care. He said, stay mad, bro. I'm ready to get to the prosecutor as part of it. I don't know how much is left on the defense's side, but they're boring me low key, and I'm ready to get into feisty Santa. Mary Malarkey says some of the info shared was not even allowed to be released in this way. Wish I could remember the legal explanation. Several lawyers had concerns about what was shared as far as the arrest affidavit goes. Maybe. Amanda Lang says that's why they do the surveys, to gauge how biased the jury pool is and how to weed out the most prejudicial potential jurors. I want a fair trial to make sure they convict the right person. That makes sense. Darlene says if allowed, they will survey other counties, and that is the intent there. Yeah, they do have to survey the other counties in order to determine which county would be better than Latah. Amanda Lang says it isn't good enough to say, well, every jurisdiction will probably be biased. They need to ask in order to know, to protect the integrity of the court process. I think it's really important. That is true. Chelsea B says Judge probably wants this case moved to Mars at this point. I think Judge wants to hear this case. Like, I think he's very interested in it. American Princess says, and the prosecutor said that he felt that since the crime happened in Latah County, that they should try to have a jury made up of citizens of Latah County. It happened in their county, right? Kimmy Locker says, I'm pretty sure the prosecution team would stay on the case, but depending on if/where, if it's moved to, they'd have to travel and work out of a hotel room instead of having a hometown advantage. That is also true. That is also true. And from what it sounds like, the judge is already annoyed with the defense. So maybe it may not be the jury that is biased. It may be the judge that's biased, right? Amanda Lang says the expert addresses the selection of bias question in a bit. Yes. Let's see. American Princess says Judge doesn't want to move the trial because he doesn't want to have to travel to another trial to the county. I don't know if I read that right. Mary Malarkey says POV, I love and respect Runkle, but he does have some opinions about prosecutors that may be a bit biased. Just saying, everyone has a little bit of bias in them. Kimmy Locker says to Mary Malarkey, he definitely got some opinions from being a defense attorney, but I think he's pretty even. Example, he's been super complimentary of Morrissey lately. I might be biased for Runkle though, LOL. Mary Malarkey says POV, the defense lawyer speaks a lot more than the prosecutor since day one, trying not to show how I voted in the poll. Chelsea B says, I think in media age, it's impossible not to hear passing details of things. Even if you're not like super paying attention to it, I agree with that. Amanda Lang says that is one of the purposes of the survey. It can help determine what questions to ask during voir dire. If it isn't foolproof, but it helps identify red flags. That's true. KR says, I feel like it's skewed. Every single stat is really percent of those who answered the phone. That's what I said. It's who's willing to talk to you about the case, right? It's whoever's willing to talk. Like the people that get scammed are the ones that's willing to talk to the scammers on the phone. So, and my opinion would be that the people willing to talk to you on the phone about the case are probably interested in the case. Now, we can't be too sure on that, but that would be my inclination. They're interested in the case, so of course they want to ask questions. They want to be in the loop, okay? It's 2024. Those answering probably are already interested. I agree. But is that truly representative of everyone? I would not agree that that's truly representative of everyone who's willing to talk on the phone. You know, the people that are like, get off my line, probably they may not know as much, right? KR says, I think the idea that it risks a small portion to see if it's going to be a problem, but if it doesn't get moved, it makes it worse in an area where they think it will already be difficult. Agreed. And he said he has opined that the case should not move. So let's see if that's the situation here. Nissa Howard says, to me, there was a whole thing in the 80s and 90s where kids remembers being abused by parents because they were fed the information, right? American Princess says to me, sorry, typo, the judge doesn't want to move the trial because he doesn't want to have to travel to another county and it's expensive. I don't really know how that works. I thought if they change the whole venue, then you get a new judge and you get a new prosecutor. But is that not, I mean, maybe the prosecutor will still work on it because they work for that county, but I would assume that you would get a new judge. Kimmy Locker says maybe we could/should do a poll to see what the Bree Hive thinks about the survey. Okay. I don't know what question to ask. If you can think of one, let me know. Chelsea B says to John Smith, I tend to agree here. Felt more like trying to taint the pool for a forced change. Boom, bingo. That was a lot of commentary as well. Okay. Let me put these prejudicial questions back out there, because remember, everyone says, oh, I haven't heard about anything in a while. And then all of a sudden, it's not a while. I just heard about it again on the phone from someone doing a survey to figure out if this case should be moved. Maybe it should be moved, because yeah, I actually do remember that fact. So that could be a potential issue too. Kimmy Locker says, I think the survey is totally fair and proper procedure, but I think it might be in the minority. I think I might be in the minority. I think that some of the questions could have been worded differently. Ask me how they should have been worded. I don't know. I'm not a surveyor. So we just kind of have to go with whatever the expert says, right? He says these are fair questions. These are fair questions, according to the expert. Y'all, we are not even halfway through. What's going on? Why he's slamming stuff over there? Sorry, y'all. Got crashes and things like that going on. Kimmy, were you able to find that longer version? If not, I'm going to try to find it here in just a second. Come on, don't make noise. Let me mute that real quick. And why did this one come out? Okay, I'm just trying to find the other video for this one. And then I'm going to read the poll. So if you guys have not voted yet, please do vote so that we can see what the thoughts are in the chat. Now, am I going to even be able to find this? This got like a bunch of Daybell stuff up. Was this uploaded as a video? That's Daybell. That's Daybell. Where did I go? Okay, let me try to search this one more time. Bryan Kohberger surveyor. Y'all, I'm just trying to find the goddamn video. Where did it go? I think this one is it.
Okay, Dr. Edelman, if you can please come forward, face the clerk, raise your right hand.
Okay, Kimmy found it as soon as I found it.
You solemnly swear that the
Is this the
testimony
link
you give in this
to
case shall be the
where
truth,
it
the whole
stopped?
truth, and nothing but the truth under penalty of perjury?
I do.
Yes. Perfect. Thank you, ma'am. Go ahead and pull this up. Let me stop sharing and then get rid of this one and then start sharing. Share screen.
But there's one that was widely reported. It's in that
Okay,
affidavit.
let's get back into it. Uh-oh. Can y'all hear that? It would help if I was actually.
And 81% of survey respondents knew that specific detail. 81% when we asked, what have you read, seen, or heard about this case? However, on the previous question, what have you read, seen, or heard about this case, the open-ended, only 8% reported it. 8% report it when you ask the open-ended question. 81% actually know the detail when you ask a recognition question. That's significant, and I can only do that analysis because we asked those questions. And 72% of people who knew that detail reported that he is guilty, compared to just 47% who don't know the detail.
Oh, I forgot to do the poll. That would be helpful, Bree. That would be helpful. Okay, so the question in the chat was, do you think Bryan Kohberger is guilty? We got 28% saying yes, absolutely. We got some strong thoughts there. We got 3% saying no, they have the wrong guy. I don't think they have the wrong guy. I will tell you that. Let me finish. And then we have, I don't know, I need more information. I don't think they have the wrong guy. I think they have the right guy. I just don't know if they have enough information to prevail on finding him guilty. If And maybe it's because I believe that if they have the wrong guy, that means the right guy is still out there running around. And I would like to hope that they actually got the right guy, and then they have to prove their case to figure out if they're going to be able to succeed on a guilty verdict. Of course, if he's not guilty, they shouldn't find a guilty verdict. But if he is guilty, they definitely should. And they definitely shouldn't find a guilty verdict and the other guy is still running around. So I'm going to go ahead and close the poll. Thank you for everyone that participated in that. I'm going to go ahead and get Bossy B to do her job. She's sleeping tonight. And then we're going to jump right back into the lovely defense, finishing up their questioning of the expert. I think I got quite a while to go, actually, and I might have overestimated my ability to finish this in time. I think I overestimated my ability to finish this in time. So I may have to go ahead and skip a little bit through the prosecution and jump over. And it's a lot. It's a lot. Okay. That was 10 minutes. Okay. Let's do this. Let's do it. Okay.
So that's the kind of analysis we look at. What do these case-specific items look like? If you know this media item, is it correlated with guilt? What percentage of people know that media item? How many people mention it in the oath? Is it consistent, or is it perfect overlap, or nobody talks about it, but they all know it? In another one, only I think it was 3% mentioned a specific detail that was on social media, widely reported in the news, not factually accurate, a misrepresentation of the truth. 45% knew it in the survey. Only 3% reported it in the open-ended comment. And it was extraordinarily prejudicial, where if you did know it, 81% of survey respondents, if they knew that detail, indicated that the defendant was guilty. 81%. Half the sample knew about it, but only 3% mentioned it when I had.
But is that only specifically to him saying that they found it guilty? Was that specifically only to that question, or to all the questions combined after you gave them 9 prejudicial facts that could affect their response? Because even if they say, oh, I didn't know about that fact, but now you've informed me of that fact, now that may have changed my mind as to whether I think that they're guilty or not. Because he asked whether he's guilty at the end, if I'm not, or after he asked the prejudicial questions, if I'm not mistaken. I could be wrong, but let's go on here.
The open-ended question. So again, if I didn't ask those questions, and the only thing I asked was the open-ended question, it would appear that people don't know a lot of prejudicial detail because they don't mention the detail when you ask that question. And that is, from my experience, doing post-conviction work, reading voir dire transcripts, coding transcripts, doing hundreds of jury selections, being involved in these cases, coding jury questionnaires. This is the phenomenon that we see all the time. It's nothing new. And the only way to look at it is by doing the survey this way.
Before I ask the question about courts relying on surveys to make decisions, using these surveys to make decisions to change venue, when you talk about things that are in the media that aren't true or might not come in, we've heard a lot about that today. Are you telling me that that's still going to be in my courtroom? Things that aren't true, that don't get brought out in trial, those are still going to be in the jurors' minds?
Absolutely. And again, there's social science research on this, looking at the impact of inadmissible content, the effectiveness of judicial instructions, and how it impacts jury decision-making. Just because you say it's not evidence doesn't mean it's not prejudicial. Just if I know it, it impacts how I view the defendant. It serves as a filter through how I process information. I might expect to hear that information when I can assume that I will, so it has an impact. One interesting study looked at jurors' ability, or participants' ability to recall the source of information. And what they found is, after a few days after a trial, people couldn't recall what information they had learned from the media and what information they recalled to learn from the trial. So they assumed stuff in the media came out in trial. The idea that I can cognitively say, okay, I know this prejudicial detail, and I'm going to put it in a box in my mind and never think about it and process everything, and it's never going to affect me. It's just, there's nothing to support that. It's kind of in our everyday lives, just our brains. Like, think about what's going on today with Trump and Biden and all that.
And with that, even if it's not like a prejudicial detail, right? Or it'll be a prejudicial detail. Even if it's not something you heard in the media, but let's say Bryan gets on the stand and he says something and the jury's like, well, I don't believe him. He doesn't come off as genuine to me. They can make determination on that too. So whatever. Everybody
has strong opinions. The idea that, oh, yeah, well, it's not legitimate or that fact is wrong. It's misinformation, so it won't affect me. There's nothing to support that. There's even research that shows you have people, they read a passage, they write something supporting a position that was in the passage, and then you tell them that information is not true. It's called belief perseverance or belief persistence. And what they find is even when you tell them that fact is not true, they still have a difficult time not believing it, and it still impacts their views. They still defend it, even then. So there's a host of research on this. The idea that we should only test things that are factually accurate and assume that the other stuff isn't prejudicial is just ridiculous.
So a massive amount of prejudicial media coverage is a factor that has to be considered in a case with this kind of coverage. Is that right?
Yes.
I want to know, though, from your experience, have you done a survey like this that contained these 9 case-specific questions where a judge decided to change venue?
Yes.
Will you tell us about that?
Yes. So in Nichols, it was a case in Washington, and this is kind of what I was referring to. So it was a defendant who had been convicted in 2012 for murder in Grant County, in Washington. Later, it was a high-profile case, and then later the conviction was thrown out. It had something to do with jury instructions or something like that, and there was going to be a new trial. And quite a bit of time had gone by, like a decade. So we did a survey because that fact, knowing that detail, would be highly prejudicial. So what we found was 42% of survey respondents had read, seen, or heard about the prior conviction when we asked that case-specific media item. However, when we asked the open-ended question, what have you read, seen, or heard about the case, only 12% mentioned it. So 12% mentioned it when you ask the open-ended question you use in voir dire, but over 42% knew about it. Now, you can never ask a juror, well, did you know a jury convicted him of murder if he didn't mention it because you're poisoning the well? And the court agreed and was worried about the effectiveness of voir dire as a remedy in that situation and granted a change of venue.
Have you had the opportunity to pay attention to any prejudicial media coverage since the hearing last week?
I have.
What is that coverage?
Well, it created a misrepresentation, false narrative that we, myself specifically, had done something wrong to poison the well, taint the jury pool, and using language like that. That became part of the narrative. I saw it on Reddit, on social media, in the news, that once again, going into this idea of what the story was, that the defense had done something wrong, debate about whether it was part of their tactic to delay, get him off on a technicality, and so on. And again, what I did, to be clear, is the standard practice in the industry, done hundreds of times in high-profile cases throughout this country. There's nothing I did to contaminate the jury pool. Everything I included was widely disseminated by the media in this county hundreds of times, if not more. And most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
And y'all can hear he is starting to get feisty because he's talking about how the defense or the prosecution made it seem like he was the one tainting the jury pool.
Did I tell you what questions to ask?
You did not.
Would you take my advice if I told you what questions to ask?
I would not. And I'll tell you why, is as I mentioned, my role is to be an objective expert to provide the court with information so the court can make a decision on if any remedial measures are necessary. I don't care what questions you want in the survey, and I don't care what questions the government wants in the survey. What I want to do is conduct a valid survey that's objective, reliable, and provides meaningful information that can be used by the court.
Do you believe comparative surveys in other counties would provide the court with more information about what to do when we get to change the venue hearing?
I do.
Why?
Because this case has received a lot of media attention across the state. It's a national case. And depending on what the results are of the survey, I'm assuming if we find that there's grounds for a change of venue here, that's a recommendation, the response will be, well, there's nowhere else to move it. Everybody's been saturated with pretrial publicity, so there's no need to change it. The point of the comparison survey is to address that question. Is there anywhere in the state where you could do that? Maybe there's not. I don't know. But that's the only way to find out. And you have to conduct the survey in the same manner. I don't know if I just ask people what they know about the case and you get general, I just recall when it happened, but you have the same guilt rate. Do they know inadmissible details? Do they know about things from that affidavit? Do they have a lot of case-specific knowledge? Or is it just a general awareness of the case? Do they drive by the house where the crime occurred? All these things that make this county unique that you want to test for in other communities. So it's not just a question of general awareness. I need to know what case-specific information they have, what misinformation they have, what media items they've been exposed to. Do they have as much case detail and knowledge as they do here? All of those things. So that's why I would suggest it's important. Without that, the only thing I can do would be to collect the media coverage and assess, for example, like, are there fewer articles published in Bonneville County or Ada County compared to here? That's all we have. I wouldn't conduct a survey that I know is going to lead to misleading information. I'm not going to do that.
To change the survey, would that go against the methodology that you use?
yes, if I change the survey and I don't conclude those items, I can't test. Well, do people know a lot of case-specific information that was widely reported? Are those specific items related to bias? Which items do they know? Do they know the ones that were all over social media or not? Like, that's the whole point of asking those questions. What you'll get is, well, I don't know much when I saw it when it first happened. I remember reading about it a while ago, but haven't seen anything lately. I know the defendant was, arrested or whatever. Or things like, oh, I followed it closely. Okay, great. I followed it closely. Does that mean they know a lot? I don't know. I can't assess just from someone said, I've read the news or I followed it quite a bit. That doesn't tell you anything. That's not meaningful information. So yes, we need to conduct it in the same fashion.
Last week, your professionalism, your work, your reputation was impugned.
I believe it was, yes.
If you're allowed, if the court says, okay, go ahead and finish these surveys, I
Giving him an opportunity to kind of defend himself here.
want comparative county information. Are you willing to still work with us?
If we do it correctly, if the idea is we want you to conduct a leading bias survey to get results that we want, then no, I'm not going to do something that undermines my credibility, my objectivity, or do it in any way that's not consistent with the procedures and standards that have been used.
Thank you. I don't have any other questions, Dr. Edelman, but the state might.
Johnson, thank you, Honor.
I mean, we'll start going backwards here, or from the back to the current topic. I'm sorry if you're feeling hurt about us raising this issue. I see you were almost breaking down with 2 minutes ago when we were talking about slide number.
So the prosecution is coming in very strong, saying, I'm sorry for hurting your feelings, which is a petty way to open up your questioning. So prosecution is sorry for hurting this guy's feelings. He's going to ask a couple of questions. I don't think we're going to be able to go through defenses the defense's cross, which basically just reiterates that this is the way that the test needs to be done. Otherwise, it's not going to be done proper. But let's get into the state. It sounds like he's a little muffled, so I may have to slow him down. So let me know if the speed is okay for y'all.
33 on slide number 31. That's not the intent, and it's certainly I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your fault, but the idea of after working really hard 15 years to develop a credible reputation and being told watching on a Zoom that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay, yes, it doesn't matter.
And please go ahead and be as angry as you like as you continue your work for the defense in this case.
Stay mad, bro. You're working for the defense.
It is a fact, though, that you don't know of the 400 citizens that were questioned on this survey. You don't know which ones of them did not already previously know any of the fact-specific representations in your questions. Isn't that true?
I do know because they answered yes or no to the question.
No. Oh, well, okay. Before you asked the question, you didn't know that. Isn't that correct?
That's correct.
And so somebody who hadn't heard the representation in that one slide that you acknowledged was false. Let's see.
And so he's going along the lines of my question is, what if I didn't know that fact? But then when you said it, I'm like, oh, okay, yeah, I think I heard that somewhere, but I never really heard it somewhere. Or I didn't know it. Or I was like, geez, that's bad for him if that's true. Even if I said, oh, no, I hadn't heard of it. Now I'm thinking that that's the truth. So the prosecution is going down that road.
You acknowledge false that Mr. Kohberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
That Mr. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that because
but you knew that was false.
I did.
Yes. And so you have now, for anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
That's false. Yes.
Yes. Okay. Thank you. Thank you.
Okay. Fine.
Defense is starting off aggressive.
And just to follow up on that, early on in your testimony, you testified, I want to make sure that you heard this correctly, that inadmissible or false information can be the most prejudicial information.
It can be.
Yes. And your surveyors put that false information into the minds of people who were asked that question who may not have previously heard it. Correct.
Correct. Relative
Thank
to
you.
media, thank you. It's mentioned it hundreds and thousands of times.
Defenses are
And just make sure we're clear too. Around the same time in your testimony, I believe you testified that you don't care if the information that you put in your specific questions to the people being surveyed is correct. That you said that, didn't you?
Right. I don't know what you mean by correct.
True or false?
I care about whether or not it's proliferated by the media.
You don't care if it's true.
No, I don't. I
No.
don't care about is it prejudicial.
So it's okay to taint people who had never heard that information before for the end result of identifying others who have and might have bias. Is that a fair statement?
I'm going to object to the questions. He's
He can answer
he's
the question.
badgering.
Wait.
Let me finish my objection.
Yeah, it's an objection.
He's badgering the witness. He's misstating his testimony, and I object.
Witness testified you didn't care if the information was correct, Judge.
Yeah, overruled. So,
May I?
so just
No, that's okay.
one person can talk at a time, and let's take down the tone a little bit.
Yes, sir.
Yeah, he's a bit feisty, and I think the prosecution is not wrong there. If they hadn't heard of that, just because it's in the media, and now I think
Okay, just so we're clear,
said it.
the questions, fact-specific questions were propounded to people who were taking the survey, did not, after asking the question even, qualify the false facts as saying this may or may not be true, or this is actually a false fact. The survey didn't tell them that what they might have heard was false.
First of all, I don't call them facts because they're media items. And then second of all, that would be ridiculous. And no, I wouldn't do that in a survey. Are you suggesting I follow up? Have you read, seen, or heard if he's stuck in? Oh, by the way, if you know that, let me tell you, it's not true.
Exactly. That's exactly what I'm suggesting, because isn't that exactly what happens in the voir dire process?
No.
Absolutely it does.
Your Honor, I'm going to object. Argumentative.
Yeah, that would
Okay, yeah, you don't get to testify exactly about that, so I'll sustain you.
Dr. Ellman, you participated as an attorney in voir dire in Idaho under Idaho laws. Have I what? Have you participated as an attorney in voir dire, conducting voir dire, criminal case in Idaho?
No, I have.
And just to be clear, because in two places, at the beginning and at the end of your testimony and your PowerPoint, this PowerPoint, you created that, Ms. Taylor. So you adopt the contents of the PowerPoint.
Yes.
Okay, thank you. Just to be clear, not every fact-specific question that your surveyors asked came directly from the probable cause affidavit. Isn't that true?
Well, to be clear, they're not facts. They're media items.
They're representations of
Your Honor,
fact
I'm going to object.
and the PC
Ask-
affidavit.
He won't let him finish.
I'm objecting and ask that he allow Dr. Edelman to complete his answer before he jumps back in.
They're simple yes or no questions.
What was your question?
Oh, yeah. Let's just say one at a time, okay? Listen to him answer, and we'll be through at some point.
Thank you.
Yeah.
So, Dr. Edelman, isn't it true that there are among the 9 fact-specific questions, that's my characterization of the 9 questions, we know which ones we're talking about. Not all of the representations in those questions came from the probable cause affidavit. Isn't that true?
That is true.
And are you aware that under Idaho law, probable cause affidavits in criminal cases become open to the public by operation of court rule once a person is arrested and appears in court?
I'm sure that's true. I'm just not used to having press conferences to tell the media to disseminate the information far and wide.
Oh,
Smart.
so let's talk about that. That press conference was made prior to Mr. Kohberger's appearance, prior to the release of the affidavit, and the press conference only referred the media to what would be part of the official court record. Isn't that true?
I don't know. All I heard was this is going to be released. I encourage you to tell your listeners and viewers and anybody who's interested in the truth.
By going to the court record and looking at the probable cause affidavit. Isn't that true?
I recall you saying, I want you to go to the court record and look at the probable cause affidavit. And what it did was
You're splitting hairs now, doctor. That's fine. I don't have any other question. Okay.
Oh,
So, okay, go ahead.
Thank you.
like that. I think
I want to start with the probable cause affidavit, and I think you testified that probable
it's
cause
in the
affidavit was spread far and wide
and then go
in
from
the media over and over again. Do you recall that?
Let me be clear. It wasn't the probable cause affidavit that was spread far and wide. It was details taken from it, put in media stories with editorial comments back and forth in the context of news stories. It wasn't, here's a document from the government that was in the court record. Let me read it to you. That's not how it works.
Well,
It's media coverage. That's how it's reported. Taken out of there, DNA stuff, all the other stuff in there, reported within the context of the news story.
We read the full affidavit on this channel.
So the news takes this document, takes things from it, and runs with it, spins with it, changes it, talks about it, and sends it out.
Yes.
Sometimes, do you think the media gets it wrong after they read something?
Sorry, what?
Does the media ever get it wrong after they read something?
Yes.
And do those stories have any less prejudice on on the reader of that media, whether they're wrong or not?
No. And going back to, I don't care if it's true or not, my focus is to assess whether or not media coverage is prejudicial, and whether or not it's led to opinions. It doesn't matter if it's true or not. You don't say, well, I won't test all this prejudicial stuff in the media because it's not true, so I won't include it in the survey, and I'll just assume that it had no impact on people. I find it convenient to be able to disseminate a whole bunch of prejudicial media coverage, saturate the community, and then say, oh, you have no right to test the impact of that information on the jury pool. So it's wonderful that you get the benefit of generating all the bias by releasing it to the media and then saying, no, you're constrained defense. You're not allowed to ask questions about it because that stuff's not true. Or you might have told one person in the jury pool a detail they didn't know. Oh, they knew the other 7 details that are highly prejudicial, but it was that one that shifted everything, and that's going to lead to the contamination. Not the thousands of newspaper stories, not the media coverage, not the stuff on social media. It was because a survey vendor called 400 people and asked the question that one person or 2 people in that panel, whoever it was in that 400, may not have known that one detail. They knew everything else. They're already biased, but it was because they learned that one detail, that's what shifted the scales. That to me is just ridiculous.
And if somebody said, I don't know anything about this case, did you stop?
Yes.
Mr. Thompson was talking to you about the difference between, in the survey, between closed questions and what can happen in voir dire.
Yes.
You're not an attorney, is that correct?
Correct.
Well, what's the difference between what you can do in a survey and what you can do in voir dire as far as your expertise?
Well, again, I sit in jury selections. I've done hundreds of them. I've done research on one of your transcripts. I've done post-trial interviews for hundreds of times. So I have a pretty good idea of how the process works. In a survey, I can ask those case-specific media items. Well, someone says, I just recall what was in the newspaper to the open. I can ask a follow-up. Have you recently heard if David Nichols was convicted by a jury for murder? Could never do that in a voir dire because you'd be poisoning the well, just like in the John Fight case we mentioned. I rarely see during voir dire somebody admits comments on something like, oh, I read this, and then there's a whole discussion and explaining to everybody, well, that's not really true. That fact was just in social media. It's wrong. That is not a normal common thing that I've seen in voir dire.
In your experience, 15 years, you said, doing this work, have you had a situation where you've been stopped midway through your process?
No.
And that's the problem.
What do you care about?
What's what?
What do you care about? I've heard you say that whether what the media sends out there, whether all of those things are actually true or whether it's a spin off other information, that's not what's important to you. What do you care about in your work?
What I'm interested in is assessing if there's prejudicial media coverage. Inadmissible prejudicial media coverage is some of the most concerning. Misinformation is some of the most concerning. What I care about is what extent of that stuff has permeated the jury pool, what do people know, and do those specific details prejudgment. Again, I just, the idea that there can be all this stuff out in the public that's misinformation, prejudicial, that benefits one side, and you're not allowed to ask if people know that detail, because you might taint one person who already knows a whole bunch of information. But that, again, like knowing the detail about the stalking comment. Okay, that person knows all this stuff, but that's the thing that's going to change everything. And now that person's poisoned because they heard it in a survey. But the fact that there's thousands of newspaper articles and television stories and comments on social media, 80% of people in this community talked about this case according to the survey. None of that matters. It's because I did a survey and asked that question. I mean, that's just, I don't even know what to say.
You still want to finish the surveys if we're allowed to do them right?
I'm sorry?
Will you still do the surveys if we're allowed to do them right?
Yes, if we're doing them correctly, I'm open to continuing. Now, I think this whole thing has created quite a whole new narrative that it's almost wrong that the defense is doing something inappropriate by doing the same standard survey that's been done hundreds of times in other cases, including in Idaho. So I don't know how people will respond because of all of this and what it's generated, but I would certainly try if we're doing the survey correctly.
Thank you. I don't have any questions.
Okay.
Okay.
So one thing I just want to sort of clear up, because it's come up here back and forth, with the questions that aren't true.
The judge needs to ask his questions as well. So I don't think he's going to be long. I know I keep saying that, but I think I'm going to let him finish, jump into the chat, see what y'all are saying, and then get into Hannah Gutierrez Reed. So we're having a long stream again tonight.
Okay, and those were not in the probable cause affidavit. And so I think it does have some bearing on the non-dissemination order, because our whole purpose, okay, both counsel were trying to protect these things from coming out to the public or to the media. That's, I think, one of the key issue, okay, or the concern about these particular statements. So there were two questions right at the end. And the ethics, okay, of the lawyers, basically this non-dissemination order is really a mirror of the ethics in Idaho, especially for the lawyers who are participating in a case like this. And one of the things that is permissive for putting this information out to the public is information contained in the public record. Okay, so the public record is a case file that is available to the public. That's a lot. And so
it does seem like the judge is leaning more towards the prosecution's area of it. I get the surveyor's point of, okay, well, this is in the media, but you can't blame the media for releasing or you can't blame the prosecution for what the media is saying based off of releasing the arrest affidavit, which the court unsealed, in which the prosecution and the court was allowed to do. You can't then go pulling out other information from media. I get that it is also prejudicial, but I think it kind of goes a little bit outside of the scope of the, just like he argued it against himself. He said, oh, well, that one little question all of a sudden tainted the jury pool. Okay, if that one little question didn't taint the jury pool, why do you need to ask it? So he kind of made arguments against himself. I get that it's prejudicial too, but it's like where the judge is going. It's not actually in the court record. It's just based off of people's speculations and their opinions. These, as far as the arrest affidavit goes, although they haven't been proven to be fact, they are the allegations made by the government entity. So they will be able to bring those facts in and present evidence to prove those things. If for whatever reason they get evidence that Bryan was stalking the girls, they can also bring those things in. The court's purpose, or the court's point, is that it's not already in the court record. So let's go on.
To then say, well, we have these other issues, okay, of concern that have been spread through the media, hundreds and hundreds and hundreds, as you've said, that we need to test that. But then it is a tightrope to balance this. So I'm just not accusing anybody. I'm just saying this is one of the things that's pushed or pulled both sides apart and puts me in a very difficult situation. Okay, trying to make that fair for everybody. Okay, so that's what that's about. I'm not asking you to answer anything about that. I'm just trying to think about the solution. I don't know if there is a solution. Okay, it's out there, but it does have some bearing on additional surveys. And what you're saying is, if you can't use this, or apply the surveys if you want to complete, that you need the same questions. Otherwise, it's not legitimate.
Yeah. Well, let me ask you this.
Okay, so if you have an answer to that, that's
Let me ask you this. So if you said you can ask certain case like media items, like the other 7, for example, that they come from the record, that's a possibility because you can still measure what we're talking about. Your specific knowledge when you ask these questions is high. The more you know, the more likely they are to be prejudiced and biased. And you see differences in aid account or a different type. Now you have to acknowledge there's these other stuff out there that's highly prejudicial, and we will not know if the rate of the awareness of those details are as significant as they are here. So then it's an unknown. So if the argument is, well, it doesn't look so bad because all I know are the things in the affidavit, for example. Well, there's this unknown out there again, because those items happen to be one of some of the more prejudicial items that we found.
Yeah, there's a death penalty case. And so when we're talking to jurors, we're going to probably talk to a lot of jurors individually.
Sure.
And it's going to be on the record. And we're going to talk about them, about what they think or what they've heard in real detail. So there's that. Okay. So I guess I'm kind of wondering too, in terms of all the people that may have been called that didn't pick up the phone or
Right.
don't want to pick up the phone because everybody knows, okay, that, oh, I don't know this person as my phone is ringing.
Yeah.
And I'm not, and then there are lots of people, including me, that would never
Right.
answer a question, okay, on the phone. So how do you deal with that? How do you balance that? There could be, 400 people out there in Latah County that say, I don't want to say anything about this.
Yeah.
How do you factor that?
Well, so you got two things. So let's unpacking both of this. So the jury selection question, like I'm sure you're familiar with these. I've been quite a bit. I've done a lot of high profile files. And from my experience, asking people in the general case, like a DUI, what do you think about DUI? And they tell you generally I'm against it. That doesn't, I have a big issue with that, whatever. That doesn't mean they can't be jurors because it's a general attitude. It's nothing case specific. And there's hundreds of studies that show general attitudes are much less predictive than specific attitudes. This is different and unique because we're talking about attitudes and beliefs specific towards this case. That's a whole different animal. And that's the unique nature of high profile cases. So when you talk to people individually, you still have the memory issue. You still have the recall issue. Like you will not elicit everything that jurors. It's just memory does not work. It doesn't matter if they're under oath, private. There's so much research on it. It doesn't, our brains don't change just because we're under oath. We work the way they work. Your other question goes to response bias. What's the response rate? Is there something unique about people you miss and so on? So there's a lot of work on that. And one of the things we do is why we collect like demographic information is to see, are we missing groups? Are we overrepresenting one group or the other? If we are, is there a relationship between that factor and bias? And there's a lot of research on response rates, and what it finds is surveys that have high response rates where like everybody takes their survey, and surveys that have low response rates, where it's like less than 10%, and you compare them with public opinion polling and so on, politics, there's no difference. You find in most instances, the results are the same in surveys. So high response rates are not necessarily correlated with more reliable, valid survey findings. And that's something they've done a lot of work on because.
And so there's like a little bit more back and forth with this expert and the judge, 10 more minutes of it, and then we'll jump into chat, and then we'll go into Hannah Gutierrez Reed. So no, we have not covered
survey rates or response rates have gone down like that. I think so. Yeah, they have.
Well, I mean, so it could be that you're just getting people who like to talk on the phone with strangers.
Yeah, and from this case, I think people are so invested in it, like a lot of unique things. So people, talking about what's happening, they're very invested in this case. It's unique. It's a small community. It's not surprising. But just what I'm finding, there's so much prejudgment, detail, and so on. I don't think I think it's fairly representative of what you're going to see. Almost everybody in this jury pool knew about the case, like comparable to like the George Floyd case. The bias was the same in terms of comparing it, not to Chauvin, who was George Floyd, but Alexander King, who was another officer on the scene. Like the rates are similar to that. So that was another high-profile case that was a lot of tension and stress, and so on. And we still got very meaningful data. And we've done so many times. Like you kind of understand, like response rates are going to be lower, but there's nothing to indicate that, for example, we're missing an important group. And if we were, we would weigh the data to account for it. So there's just
so in Latah County, it was about 1% of the population.
Yeah.
So hypothetically, if we say, oh, I mean, one of these counties that are interested in data, just bias, for other reasons too. But would it be 1% of the population in Boise? No. So okay, so that's I was kind of wondering about that. You have to talk about 2,000 people or something. Okay.
So how that
go ahead.
Yeah, so it's a great question. So you can take a small sample and generalize to the population. Is that correct? So like if you look at surveys of the United States, the sample sizes are similar to what we did here. Maybe it's 1,000. And now you're generalizing to every city, county, and so on across the country. Everybody has a known probability of being selected. How you figure sample size, there's this called power analysis. So how you see polls of like you see a number like 90%, and they say plus or minus 5%. So it's either 85 to 95%. Basically, it's plus or minus 5%. That's kind of industry standard. And you take a conservative approach. So let's say you ask a yes or no question. You would say 50% would say yes, and 50% would say no. So that's a lot of variance. So that's the worst case scenario. How many people do you need to talk to? So if that happens, your confidence interval is plus or minus 5%. And that comes out to 400. So if you did Ada County, it would be 400, and your confidence interval would be the same as it is here with a smaller population. Anyway, so as long as it is using the general concept of a randomized sample, you can generalize that population with this.
So
okay, I lied. We're not going to listen to the rest of that. He's still talking survey stuff. And basically, the judge does not make a decision. Surprise, surprise. And he's going to give them their decision a little bit later on. So I'm going to jump into chat and see what y'all have to say. The judge, to me, is leaning more towards the prosecution side and changing the survey, maybe not getting rid of the full survey, but maybe changing those last two questions that were just in the media, because you can't say, okay, well, the prosecution has tainted the jury pool, but you're using questions that the prosecution or information that the prosecution did not put out. So let's go ahead and have Bossy B bring us in. And just to warn y'all, for Hannah Gutierrez Reed, we're not going to listen to all of the impact statements. We're going to kind of jump around. We're going to listen to the state. We're going to listen to Hannah. We're going to listen to her dad. We're going to listen to Helena's mom, maybe her sister's statement, and then Joel Souza's statement. And then from there, we'll go ahead and finish off the defense, and then we'll be done because this is a long stream. I always overestimate. I always think I can do things quickly. And this is not going quickly. Anyways, let's jump into it. We got American Princess saying, when Chad Daybell requested a change of venue and it was approved, the judge stayed with the case. Okay. And it could happen that way. I just don't know. Okay. I'm not going to pretend like I do know. MZ says, wow, what a big gap. MZ says, I'm referring to the expert witness point. I don't know exactly what point you're referring to. Mary Malarkey says to Kimmy Locker, haha, love and respect for Runkle all around. He does so much good for people in the people in need of representation up there. He's a good egg. Love that good egg. Chelsea B says, you know who I'm so curious to hear from? The surviving roommates. I know, right? I wonder if they're going to testify. Cheryl Reed says to Chelsea B, didn't one of them actually see Bryan Kohberger? They saw a person. It's not confirmed whether it's Bryan Kohberger or not. Chelsea B says to Cheryl Reed, yes, my understanding is they say she opened the door and saw someone walking by, but they just described like the bushy eyebrows, similar height man, but I mean, it was nighttime. Could she really see him? Probably not. Amanda Lang said the prosecution maligned his professional integrity in the press. To be fair, Chelsea B says, my DNA has never ended up on a knife sheath in a quadruple murder scene. So that makes me think there's a case, LOL. That is, I mean, unless someone took your knife sheath, right? And didn't it have like his initials on it or something like that? Don't let me start lying. I'm pretty sure it had like his initials or something on it. American Princess says, I heard the DNA on the sheath is a touch DNA and it's a partial print, but I need to read that declaration again. I don't know enough about that. Mary Malarkey says to American Princess, that was one of the issues lawyers were concerned about as something that was not released to the public. The media never said the DNA on the sheath is a match. They said they found DNA, but they didn't say where it was at, if I'm not mistaken. American Princess says to Mary Malarkey, on June 21, 2023, it was reported in the media sample from Bryan Kohberger's DNA matches DNA found on Idaho crime scene, court's documents say. Yeah, so I don't think it said exactly what, it just said it was in the crime scene, not on the sheath, right? Amanda Lang says it is really considered professional for the prosecution to publicly malign an expert when the issue hasn't even been addressed by the court or experts' professionalism tested. And that's some things that he's going to have to deal with. Chelsea B says, sorry, you're an expert. Don't come in here with angry teen energy. This can't be the first time you've been questioned. Oh gosh, are you guys chatting in the chat? Amanda Lang says this is the prosecution starting off aggressively, not the defense. Yes, it was the prosecution. Cheryl Reed says, I can't believe he's so offended. This can't be the first time it's happened to him, especially as an expert. Yeah, he was a little sensitive. But, you know, to each their own. This is a big case. So maybe he felt a little bit more pressure there. Chelsea B says, I think they are responding aggressively to how the defense came in. Because they're basically saying, oh, this one little question doesn't affect anything, but also it's the prosecution's fault for unsealing the document when the prosecution didn't have control over that. That's the court made that decision. American Princess says, I would like a new judge, please. You don't want judge? Cheryl Reed says the judge seems to be enjoying the banter. The judge is not making decisions, but as a practicing lawyer, there are several judges that do not like to make decisions, in my opinion. Sentient Dreamer says the expert did care that it might be prejudicial. He said he didn't care if it was true or false. The whole purpose of the survey is to determine whether it's prejudicial and if it has an effect on whether the jury believes that he's guilty or not. So the whole purpose of the test is to use prejudicial information. If it came from the affidavit, his approach is also information that came from just media sources making things up. And that's what the prosecution had a problem with. John Smith says, right judge is a wimp. He did not stand on business in telling the prosecutor to calm down and stop cutting the man off. Amanda Lang says, a probable cause affidavit is also not proof. It's allegations. Correct. That is correct. It is all allegations and maybe not shade, but it is allegations that supported getting him arrested. But it has not been proven as fact in the court because there has been no judgment here. Sentient Dreamer says the prosecutor sounds bad. He is aggressive. Mary Malaki says lawyers have also weighed in on their disbelief that the defense didn't look over the surveyor's questionnaire to make sure nothing wasn't released. Would it be in there? And that's what I'm concerned about. It kind of seems like if he is an objective surveyor, right? Then both sides would have weighed in on, okay, those questions aren't appropriate. Okay, we approve of this survey. Let it go out. If he was objective, but as the prosecutor keeps saying, yeah, you go ahead and work with the defense. Like prosecutor Santa Bill was using fighting words. Okay, he had fighting energy in there. But yeah, he said, you work for the defense. You did not consult with us. You didn't even consult with the defense. You just threw some questions out there and started asking people, right? But if he was really objective, then both people, the court probably should have approved the questions, right? Not just they go out there willy-nilly. And then they wouldn't have this hearing if they would have got the questions approved. American Princess says to Mary Malarkey, I agree that Anne should have told the expert not to ask about DNA on the sheath. I don't know all the questions. Mary Malarkey says, American Princess, yeah, this is also tricky. How do you have the defense look at the questions without being accused of playing a role in the survey? I think they both should have looked. I think it should have been approved by the court. I don't know if that's the methodology that they normally use, but I do think that they should have been approved by the court. But also Homeboy said even if the defense or the prosecutor would have wanted him to ask certain questions, he wouldn't have done it. But I think it would have been his obligation to leave off certain questions, but then he might find that his test is not objective. So I don't know how you win this one. American Princess says bad Santa. Alexis Carney says, how is something prejudicial if it's true though? The thing is that it is prejudicial. It goes against him. Just because it's prejudicial does not mean it's not inadmissible. I mean, that it doesn't mean it's inadmissible just because it's prejudicial. If you literally have a picture or a video of a defendant with a smoking gun in his hand, he cannot say, objection, Your Honor, that video is prejudicial. That video comes in, okay? You can't just object because it's prejudicial. You just have to prove that it is true, right? And as far as like character testimony, if it's too prejudicial, then something like that couldn't come in. And there's other evidence rules to whereas if it's too prejudicial, then it can't come in. But not just, well, if you come in and say, okay, well, my mom's going to testify about how good of a person I am. Okay, ma'am, you are not on trial for being a good person. You're on trial for driving recklessly. There's no point for your mom to come in and testify, maybe not find it character evidence. We don't need it, right? So it's along those lines. So prejudicial things can come in. So there are prejudicial things that are true and they can come in. But you have to satisfy whatever evidence rule you're trying to satisfy. Alexis Carney says, I thought the definition of prejudice includes an unfounded opinion. No, a prejudicial is just that it's bad. It's more prejudicial than probative. So it's going to be more hurtful than it would prove your point. You can probably use some kind of other evidence to prove your point, right? So your mom, I mean, that I can't even give an example right now because I don't even know if that would be correct. But either way it goes, when you're talking about prejudice, it has to be more prejudicial than probative to not come in. So prejudicial things can come in. If you have a video of the man shooting somebody, that's more probative than prejudicial. You are in the video shooting someone. So I don't want to go into it. It's a lot, but it's not a lot, right? I hope that makes sense. Kimmy Locker says to Alexis Carney, the jury isn't supposed to have any opinions before the trial, though, because the state has the burden of the proof. You can, yes, that's what they try to do. That is what they try to do. Some people form opinions within the first witness, so you never know. Cheryl Reed says, I think the survey is important. I just think the timing was wrong and the defense should have informed prosecution. I think it needed a little bit more parameters on it. I would agree with that. Carolyn Lower says, Judge, children, behave yourself. That is what they're acting like. Amanda Lang says, it isn't even a question of who is to blame about the information is in the public. The question is whether there is information in the public creating undue bias. The question needs to be asked. Yeah, but the way that the interview was going is that prosecution was blaming defense and defense was blaming prosecution. And so that is why I am explaining it like that. Sentient Dreamer says the judge's questions make more sense to me and are eliminating more confusion for me. The judge definitely was a lot more direct versus the defense just trying to prove their point and only asking questions that went to their point and all the words sounding scientific and we don't really know what they're saying versus the prosecution just being super aggressive and just saying, why were you being mean to me, and telling everybody that I told everyone to disseminate all of the information in the world. They would have disseminated it whether I gave them the permission to or not, right? The judge was like, okay, but you only did 1%, right? So how is that going to be helpful? Okay, but did you have to ask that question because blah, blah, blah? The judge was definitely more direct. And guess what? Who has to understand the testimony is the judge. So if neither the prosecution or the defense is doing a good job asking questions, neither one of them are going to get their way. The judge had to ask his own questions. Sentient Dreamer says the prosecutor, he just seems to miss the mark and alienates me from his position and POV. I agree with that. I think his argument was more about why you trying to embarrass me, bro? And I feel like the witness was coming back at him like, why are you trying to embarrass me, bro? Amanda Lang says, if they change the survey, it invalidates the results. If they change the survey, they have to redo the survey for both Latah County and all the other counties that they're going to interview or they're going to survey. Amanda Lang says, unless they redo the entire new survey. Yes, that's what they would have to do. And that's what the judge said. In the jurisdiction they already polled. Yes. That's what they would have to do. Rachel Mills says, I need the judge shade. Chelsea B says, Bree, are you going to cover Hannah's jail calls? Not on this stream. Not on this stream. Indigo Bloops, I don't know if I will be able to get to it this week. Indigo Bloop says, I'm 100% in support of the expert. It's so easy to misunderstand sociological studies, but everything he's saying checks out as solid science as a biochem major. I don't think that he's wrong. I think that he may have had I guess he's the expert, so he's the one that's able to do. And the way that I'm changing my topic a lot, but the way that the prosecutor could have combated that was to get their own expert. Alexis Carney says, your reaction to the judge on hearing is what I really want to see. Oh, Hannah Gutierrez Reed. Okay, we'll get to it. Indigo Bloop says, if these surveys are conducted regularly, it could be a serious appealable issue if the judge denies finishing the survey. I don't think he's going to deny finishing the survey. I think he's going to make them start over with rules. I think they're going to have rules for the survey. Alexis Carney says, I don't think they're going to cancel the survey. I think they're going to make them start over with rules. Alexis Carney says, laughing my A off. I work from home and bill my clients and send them a log with estimated hours versus actual hours for billables. And let me tell you how wrong I can be sometimes. Yeah. Rachel Mills says the judges in Britney Spears' conservatorship were wishy-washy. I didn't follow that one. KR says, don't both sides get input on juror questionnaire, jury instruction, etc. I don't love the idea that the defense agents talking to potential jurors one-on-one without input for both in the court. I agree with you there. I think that the judge is going to put some rules and parameters on these questions. Amanda Lang says, but the judge did not define public record in the order. Information in the public domain is a fair definition of public record, especially in the context of a study check and bias caused by media. I think as attorneys and judge, the understanding of the definition would have been the public record, which is what is on the docket. So that would be up to the judge to decide whether the defense took it too far, and she should have known that public record is what's in the what you can pull up from the court, from police, public record, right? Not media stories from WikiHow and Wikipedia and all of these other sources. Public record are generally things you can go and subpoena. You do not have to go and subpoena an article from Yahoo News, right? So I think that the defense probably took it a step too far to say, oh, well, this is public record. Now, if you say this is in the public domain, that's a whole different statement, right? You can do anything in the public domain, but public record is generally limited to things that are, you don't need your social security to get this information. You don't need to ask the person's permission to get this information. And you are kind of governed by a government agency is what we're talking. We're talking about the title to your house. That's public record. You got the recorder's office, right? We're talking about marriage licenses. We're talking about arrest records. We're talking about who's in jail right now. We're talking about court orders. Those are public records. We have confidential cases. You cannot just get those documents. So I think that the defense should have understood that public record meant public record, not public domain. Those are two different things. Amanda Lang says, question, is the court allowed to dictate how either party prepares their case? Like, are they allowed to dictate who is investigated, who is questioned, etc.? Isn't that generally unfair constraint? I don't think so. They're allowed to put rules on things. We're not going over here. We're not going to go interview people way in Canada. Why would we be interviewing anybody in Canada if they never touched foot in Latah County? So no, unless I'm not understanding your questions. They can put limits on things. They can limit how long your brief is. It just depends on what you're asking, what they can limit. Chelsea B says, that's the Daryl Brooks defense. It was me on the video, but it wasn't me. It looked like me, but that's not me. I don't know about you. KR says, this really feels like an area that should be truly neutral and requested of the court to handle. If you are claiming to be an objective surveyor to figure out if the case should move, it does sound like something that the court should handle, right? Or at least that both parties agree on. Not something that one side should be doing without the court's permission / parameters. I agree with that. But also, I don't do criminal cases, so I could be wrong. Jamie F says, Bree, what do you practice, defense or prosecution? Just listening to all sides, so wanted to see what side you are coming from. I do not practice criminal at all. I am a civil attorney. I do family law. I do divorces. So I represent the person responding. I represent the person that's the petition. But really, no one's being prosecuted, and no one's. I mean, people, when you don't have to pay, when you don't want to pay, you're on the defense, right? You're on the defense when you don't want to pay. So I don't practice a side. It's just whoever we work with. We can have the petitioner or the respondent. We can have the person, the respondent could be the one requesting the money. It just flips. So I do not do criminal. So that's what I said. I could be wrong. Y'all could be right. I could be completely wrong. I'm just giving my opinion. Indigo Bloop says, I totally disagree with the notion that the defense should have conferred with the prosecution or the judge beforehand. The expert looked only at what was in the media, and it sounds like standard procedure. And that's what he testified to. So that's all we can go by, because the prosecutor did not hire their own expert to combat it. Just like you guys seen in the Hannah Gutierrez Reed case, they prosecutors had an expert, defense had an expert that pointed the gun at the judge. So it just really depends. It really depends. Mary Malaki says, love lawyer Bree using homeboy. I am not a stuffy lawyer, okay? I thought that's what we knew on this channel. Kimmy Walker says to Indigo Bloop, I 100% agree. Neither the prosecutor nor the judge are experts in this field. Indigo Bloop says the number of people surveyed is carefully conducted to be just big enough to be generally reliable, but not enough to taint the pool in any significant way compared to the media itself. Amanda Lang says more people know about the survey because the prosecution brought all this attention to it. Couldn't this have been dealt with under seal with the court before going public? I mean, I think the argument could be the same as far as putting the survey out there without dealing with it in the court too. So if we're going to want the court to handle things, if the defense is going to want to do things and want that under seal, then it needs to just all the way start under seal. Not, okay, well, we're just going to seal this part and not this part. Indigo Bloop says, OMG, Amanda, I didn't even think about that. Total Streisand effect. They did bring attention to it. Kimmy Walker says to Amanda Lang, right, the prosecutor not only brought a ton of attention to the survey's existence, but read the actual questions he allegedly finds so problematic with the public hearing, like, question mark, it's going to make people doubt the defense. Jamie F says, since I have a sociology degree, I would answer the questions. You have to be willing to answer those questions. Mary Malarkey says, did a refresh, channel has 64 likes. Thank you very much for letting us know that. Amanda Lane says, I don't know that the survey would even be valid given the rules the prosecution is asking for. It's like forcing the survey to be done with blinders on. The expert explained why it's problematic. But also the expert said that one question is not going to taint the jury pool. So I don't know how that then reflects on it being done without with blinders on. He testified multiple times that it's just one little question. How could you say my one little question tainted the jury pool when they had all of this other information? Why is the information from the affidavit not enough? If you're saying maybe one or two people didn't know it out of all the people that were saying guilty. So I don't, like I said, the arguments kind of go against themselves. Amanda Lang says the jury pool lives in the public domain. They are biased on what's the public domain. I want a jury that will get it right, not people influenced by the media. And that's what voir dire is for. And Indigo Bloop says, I agree 100% with Amanda L. Indigo Bloop says, I think that if the defense was being super thorough, they would have gotten permission from the judge. However, that reveals and draws attention to the key defense strategy to the prosecution. They would have to give their results to the prosecution anyway. So I don't see what's the point of being secretive. The Amanda Lang says the court is not an expert in sociological surveying. I am really uncomfortable with non-experts changing standard practice. I don't want a trial that confirms my bias. I want one that finds the truth. Makes sense. Indigo Bloop says, Amanda, this is something that happens a lot in courtrooms. The judge makes the decision. I can tell you 1,000,009 times where I think that the judge gets it wrong. It is what it is. It's quite unnerving that there have been cases where it's really been problematic. There needs to be a better system, I think. Amanda Lang says the expert said that one question won't taint the jury pool because a few people were exposed to it, not because of the content of the question. Amanda Lang says, given the results is different than letting the other side dictate strategy. I don't know if it's dictating strategy. Anyways, let's go on to what do you call it? Hannah Gutierrez Reed. Let's jump into that. Okay, let me see where we want to start off with. I think we already have the state pulled up. If you guys don't remember what we're talking about, we covered Hannah Gutierrez Reed. We didn't cover it gavel to gavel, but we covered a lot of it. She was the armorer on the Rust set, and she was found guilty of involuntary manslaughter. She is now going to her hearing to be sentenced. She faces up to 18 months in prison. I am sure a lot of you have seen this already. It came out yesterday. And a lot of people have already covered it. So, but we're going to go and we're going to give our reaction to it. So let me go ahead and share the screen. Okay, here we go. There we go. Make her bigger. Uh-oh. Let me see if the volume's fine on this. Can y'all hear that?
All right. I wasn't sure exactly what recommendation would be appropriate in this unprecedented case until last week when I completed the review of Ms. Gutierrez's jail calls. It was my sincere hope during this process that there would be some moment when Ms. Gutierrez took responsibility, expressed some level of remorse that was genuine, and that moment has never come. Ms. Gutierrez continues to refuse to accept responsibility for her role in the death of Helena Hutchins. Rather than accept responsibility, she has chosen to place blame on the witnesses who testified against her, me, you, the jurors, the set medic, and the paramedics who tried to save Ms. Hutchins' life. Her jail calls, and there were probably close to 200 of them, tell us who Ms. Gutierrez really is. And in the state's opinion, the content and tone.
My thing is, did she think that the jail calls were not being recorded? Like, who advised her of that? Like, come on now.
Of her calls demonstrates that Ms. Gutierrez should not receive any type of a reduced sentence. Helena Hutchins died due to a cascade of safety violations that began with Ms. Gutierrez introducing live rounds to the movie set, loading one into a prop gun, telling the members of the crew that it was a cold gun, thereby ensuring that it would make its way into the hands of Mr. Baldwin. That conduct, absent responsibility or remorse, is deserving of a sentence of 18 months in the Department of Corrections with a designation as a serious violent offender, and that is what the state will be requesting today. And those are the only arguments I intend to make in terms of sentencing. I would like to move into the presentation of the witnesses who would like to address the court on behalf of Ms. Hutchins and her family. I would like to start with Craig Mizrahi. Mr. Mizrahi.
I've missed seeing Baldy. I'm very surprised about that. And I do want to actually listen to the agent, and then we'll jump to the next people.
Your Honor, my name is Craig Mizrahi, and I was Helena's agent. I was compelled to be present today.
Okay, let me slow it down because he's going quickly.
Yes.
Talk a little into the microphone.
More into the mic. Is that better?
Yes.
Okay. I was compelled to be present today to express the impact of the loss of Helena, who was a cherished friend, wife, mother, and artist, senselessly lost on October 21st, 2021. I was first introduced to Helena when a mutual friend sent me samples of her cinematography. I was pleasantly surprised to see how mature and refined it was, especially given the small budgets she was working with. I imagined what she could do if given the time and resources of a large film, and I instantly knew I wanted to work with her. What stood out for me was her passion, her intense preparation, her resourcefulness and creativity on set, and the kindness and generosity she showed to all those she worked with. In getting to know her husband, Matt, it was clear that he and their son, Andros, supported every career move she made and accepted the very difficult reality that she would have to travel for work very often. This rare combination of talent, work ethic, collaboration, and family support was what truly set her apart. In 2021, Helena's star continued to rise. Her name was mentioned around Hollywood as someone to watch, and just 2 weeks before she began on Rust, Helena got her first meeting on a big studio film. She came in a close second for that job, and instead of focusing on why it didn't go her way, she felt great confidence that she was finally playing with the big boys. When Rust came her way, she felt excited for the visual challenge that a Western would bring. She enjoyed meeting the director, Joel, and believed in his vision for the film, so we went for it. 2 days before she died, Helena called me. It was very late, but she wanted to say she just had dinner with Joel and Alec, and she was so happy to be working with them. She felt the film would be a great next step and was excited for what was to come in 2022. I agreed and said, sleep well, tomorrow's another big day. That was the last time I spoke to Helena. October 21st was a fateful day that would change the lives of so many. Most of all, Andros, who at 9 years old, would have to somehow comprehend the terrifying reality of losing his mother in this way. In the time that's passed, while the pain persists, the circumstances surrounding the disaster force upon us so many questions, with one in particular above all: how could this have happened? It's my opinion that, generally speaking, film producers are responsible to ensure the cast and crew members hired are experienced enough to handle their jobs. And when it comes to hiring the armorer on a Western, I believe safety is the only job. So when the producers hired someone with virtually no experience to not only be the armorer, but also the assistant prop master, two very challenging positions in their own right, they made a crucial decision to put the safety of their cast and crew on the back burner. As for Ms. Gutierrez-Reed, it's my opinion that she should not have held either position, much less both, but that once accepted, the responsibility should have been taken more seriously. Sadly, it wasn't, and we all know the result. Since that terrible day, I've spoken with hundreds of producers, film executives, and directors about how we can come together as an industry to make sets safer from gun violence. But the truth is that if Ms. Gutierrez-Reed and the producers of Rust simply followed the decades-old written guidelines for the film industry, specifically the use of firearms and ammunition, this tragedy would never have happened. In that sense, I hope we can all agree that this was not a simple accident. It was a chain of events that led to the killing of someone. and that chain would have been broken if the armor was doing the job she was hired to do. I often think about what Helena's future would have been, and it makes me smile. I can assure you it would have been bright, filled with spending time with Andros and watching him grow up. She would have been able to help her support her family in Ukraine, especially when they needed her most through the horror of war. She would have traveled the world shooting beautiful images and eventually becoming the director that would change hearts and minds with her poignant and purposeful storytelling. In the end, she'd likely finish her career as she started, at the American Film Institute, getting back to the next generation of filmmakers. Sadly, we'll never know because Helena's life was taken away from us much too soon. So today we stand determined to seek justice for Helena, to hold accountable those responsible for her death, and to ensure that such a tragedy never occurs again. I want to thank Ms. Morrissey and her team for having me here today, and thank you, Your Honor, for your service in the case.
Thank you.
Okay, so we started off with the state. Not super surprised that their opening was so short. I thought she was gonna go a little bit more into the jail calls, but I think that was short and sweet, and to get into the victim impact statements, which are going to be the more important parts of this. So I'm just trying to skip up to Joel Souza will be the next person that we listen to. And I'm sorry to her friends, but we're skipping over a lot of her friends just because we are 2.5 hours into our stream.
Yes,
so
we can hear you.
Let's go ahead and jump into Joel Souza. Make sure y'all are leaving y'all chats. I want to hear your opinions about it. Let's jump into Joel Souza. Oh, that's not what. There we go.
Thank you. I would like to thank the court as well as Ms. Morrissey and her team for allowing me to speak today. I struggled with what to say here today because what I want is simply not possible. I want that none of this ever happened, that everyone's okay and that lives weren't destroyed, and that, worst of all, his life wasn't lost. I would not presume to speak for Helena, nor for her husband or her son, for her parents or her sister, but I would like to say something on their behalf, if I might. Helena's parents lost their daughter. Her sister lost a sibling and confidant. Matt lost his wife, the other half of himself. And Helena's son lost not only his mother, but everything she had to offer him for the rest of her life. Every kind word, every loving gesture, every support, every influence, every life's lesson, the course of his life has been irrevocably altered. And the world lost not only a person that was a gifted artist, but a truly kind and compassionate person, which often seem to be in short supply these days. As for myself, the last 2.5 years are difficult to put into words. What it's done to me and the burdens it's placed on me, both emotionally and physically, are my private burdens, and I think I'll choose to keep.
And one other important thing to think about Joel Souza is it could have been him. He was also shot in this incident as well. And if she wasn't there, could it have potentially hit him somewhere else, right?
Keep them that way today. What I will say is that one moment the world made sense, and the next moment it didn't, and it still doesn't, and I don't know if it ever will again. So again, what I really want, I can't have. I want everyone damaged by Ms. Reed's failures that day to find peace. I want this whole thing not to have been consumed by the world as some sick form of mass entertainment. I want to still believe in the better angels of our nature. I want the pain to go away. I want to be who I was before this happened, and above all, I want Helena to be back home with her husband and son in the house she never got to live in. Helena not only had an incredible talent for her art, but she had a talent for life. She was a touchstone for all who knew her, and those of us who were lucky enough to have shared in her fleeting time on this planet are better for it. Thank you.
Thank you.
Okay, and then we're going to...
We have a brief written statement by one of Helena's friends, Anya Bay, and that will be read by Alexander James.
I think we can skip this one.
Come on, Your Honor.
Sorry, let me skip it to her mom. Sorry, friend.
Хатченко, мене звуть Ольга. Сьогодні я хотіла б вам розказати про свою доньку, яка була дуже талановита, гарна, дуже гарно вчилась, дуже добре до нас ставилась.
And mom is on captions because she's clearly speaking a different language.
Я пам'ятаю той день, коли її не стало. Мені дуже тяжко. Дуже тяжко без неї.
I'm going to speed her up a little bit more because she's pausing a lot. And I think we can read it faster than that.
Ось в університеті. Потім вона родила гарного хлопчика, мого внука, з яким я зараз не маю можливості бачити. Вона була дуже гарною матір'ю, але більше всього вона працювати любила.
That's sad she can't see her grandson anymore.
Берегла за моє життя. Дуже тяжко дивитися, як дитина росте без матері. Я хотіла б ще сказати, що вона вчилася в школі дуже гарно, невідмінно. Вже закінчила всі вузи, в яких вона навчалася.
That she got good
Я
grades.
від усіх чула тільки гарні слова. І сьогодні мені не проходиться біль втрати. Пила до них кожен рік. Я бачила, як Амброс підростає. Як він на неї дуже схожий. Оля дуже нас всіх любила. Вона завжди говорила: мама, я хочу, щоб ви жили краще. Весь час вона мене прилишала до себе. Вона хотіла, щоб я була поруч. Але оскільки ще Світлана була не зовсім дорослою, я не могла поїхати. Я їй обіцяла, що коли Свята буде замужем, коли в неї буде чоловік, я приїду обов'язково. Але я не встигла. У Галі дуже було багато друзів, які завжди приходили до нас, з якими вона старалась підтримувати контакти. Вона всім дзвонила. Ми з нею созванювались кожну неділю. У нас був день, це субота або неділя, ми завжди спілкувалися годинами. Кращого друга, ніж Галя, в мене не було. Могла поділитися зі мною усім. В неї дуже гарна сім'я була. Але цей день перевернув все життя. Мені дуже важко без неї. Я весь час чекаю, коли я з нею зустрінусь.
That's very sad.
Але я дала собі слово, що я обов'язково побачу, що виросте, коли він буде навчатися, коли він жениться, коли в нього буде своя сім'я. Я повинна триматися.
She wants to see her grandson grow up.
Я не можу. Коли Галя загинула, було 3 години ночі у нас. Я не могла заснути, я до 3 ночі не спала, мені було дуже тривожно. А в 3 часа я побачила, що дзвонить мед. Я дуже перелякалася. Значить, щось случилось. Бо вночі він ніколи мені не дзвонив.
And that Matt called her.
І він мені довго сказати, що сталося. Він тільки сказав: мама, у нас біда. І хвилин 5 він не міг сказати. Я кажу: договорив вже, що сталося? Каже: Гарі немає. Після того я не пам'ятаю нічого. Я була одна вдома. Я кричала.
So she found out at 3 a.m. by
Я йому ще
herself.
говорю, може ще не ясно, може ще все буде добре. Але він мені сказав, що її немає.
And Hannah blames the
Дуже
ambulance.
важко втрачати дітей. Це словами не передати. І час не допомагає. Пройшло 2,5 роки. А мені стає ще гірше. Якщо перший рік я ще думала, ждала, що вона приїде. А цей рік я себе настраювала, пробувала змиритися з тим, що сталося. Але, мабуть, я слабка. Хоча Галя казала, що ти мама сильна. Ну, в мене не виходить. Хочу сказати, що мені легше не стане від того, що хоч засудять на скільки років. Це не має значення. Але я хочу, щоб була справедливість, що хтось винуватий, хай понесе покарання за свій злочин. Мені дуже хотілося, щоб до мене хтось підійшов, мені поспівчував, вибачився. Подивився
So
просто в
they
очі, мені
haven't
хотілося подивитися.
apologized or expressed their
Цим людям.
condolences to her.
Може, мені було б легше.
No one ever came to
Але
express.
ніхто не підійшов. Я була на похоронах. Я їздила в минулому році, в жовтні місяці. Але я,
No one came to her funeral.
кроме
but
Галіних друзів,
friends.
нікого не бачила. І боляче. Люди, які винуваті, вони навіть не підійшли до матері.
Basically saying that
Я не
Hannah
можу
didn't
зробити.
even come to the funeral.
Ці люди, які причепні до смерті Галі, ніхто до мене не підходив, ніхто не вибачався,
No one
ніхто не
responsible
співчував.
ever came to her funeral, just her friend. And they never
Вона дуже
expressed
багато
to
працювала.
her.
В неї весь час був розписаний. Але більше всього в житті вона любила свого сина. Я не знаю, у них настільки були відносини. Розумієте? Вона просто не могла надихатися їм. Вона дзвонила йому кожен день, вона розказувала йому казки, вона все йому розповідала про роботу. От. Говорила на добраніч, і він відпочивав. Це було кожен день. Не було такого дня, щоб вона не дзвонила йому, коли була відрядження. Завжди посміхалась, була весела, щаслива така. І дуже тішилась тим, що в неї все виходить, що в неї все складається так, як вона хотіла. Я думаю, що вона була щаслива. В сімейних відносинах в них все було добре.
Helena wanted to have
Вона ще дуже
another
хотіла
baby, a baby
дівчинку.
girl.
Перший місяць я була там цілий місяць. Коли ми приїхали, я попросила, вони могли кремірувати її не в Мехіко, але я попросила, я хотіла попрощатися. Привезли в Лос-Анджелес. Ми попрощалися, а прах ми забирали через 2 неділі. І тоді
Sounds like
похоронили її
cremated.
на кладбище Голлівуд навсегда називається. В центрі города, міста. Дуже в красивому місці, там, де проходять фільми всі нові, різні.
Got a funeral,
Там
a
велика
place where
сцена,
they shoot
там
film.
збирається дуже багато людей, і там показують нові фільми, які виходять. Вона рядом з сценою похована. Канал красивий, там лебеді плавають. Дуже місце гарне.
Sorry, I'm gonna mute the music because we do not want to get struck by YouTube for music playing. Her poor mom. Her poor mom, right? I said we were gonna listen to the sister, but that one is also in a different language. So if you guys want to check this video out, you can. I'm gonna jump into the kind of montage that they put together of pictures of Helena. So let's go ahead. And I'm gonna keep it muted because I believe that one's playing music as well. See someone in the chat saying they believe that Hannah's crying was fake. It did look very forced and fake. And I would assume she would be crying a little bit more right now rather than a lot in the beginning of the thing. So let's see here. They're trying to pull it up. Okay. So this is Helena Hutchins, and they're going to do like a video slideshow of her. I'm going to put it up a little faster because I know they're going to show it for a while for each picture. It just kind of shows her growing up to remember her, and then they're going to jump into the defensive side of things to kind of tell Hannah's side of the story. And Hannah's actually going to speak, which, I mean, it surprises me, but not really, right? So, but she was very beautiful, and I did not realize she was as young as she is. So that's really sad to see. Did not realize she was that young. So she had like a whole life. I really did not realize she was as young as she was, to tell you guys the truth. So this is a little bit much for me. I thought she was like a little bit older. So there's that. But it should be almost over here. So let me see some chats while that goes through. We got Indigo Bloop saying, thanks for the back and forth, Bree. In chat, it's one of my favorite things about live streams. Sorry. About live streams, Deaf thinking about things. Yeah, no problem. We love for the people to have the opinion. So don't. Sometimes we get stuck in our opinion. Sometimes I get stuck in my opinion. So no, I love the discourse. The discourse is wonderful. Let me go ahead and take this down and get back into it's playing music. Let me stop the music. Let's go to the next point of things. Let's see if that stopped it. Okay, Hannah's gonna talk now.
First and foremost, my heart aches for the Hutchins family and friends and colleagues as well. And it has since the day this tragedy occurred. Helena has been and always will be an inspiration to me. I understand she was taken too soon, and I pray that you all find peace. I am beyond grateful that Joel survived that terrible day. My heart goes out to the film industry for the devastating pain that this tragedy caused and the old wounds that have been reopened. I am saddened by the way the media sensationalized our traumatic tragedy and portrayed me as a complete monster, which has actually been the total opposite of what's been in my heart.
And pay attention.
Your Honor, when I took on Rust, I was young and I was naive, but I took my job as seriously as I knew how to. Despite not having proper time, resources, and staffing, when things got tough, I just did my best to handle it. Today, I humbly ask you to consider probation, a probation where I can contribute to society through community service, and I can continue my counseling, and I welcome any classes that you may deem necessary for me to attend. I give you my word now.
What classes? There's no requirement.
That I would strictly follow the rules and respect the parameters of that probation. I beg you, please don't give me more time.
More time.
The jury has found me in part at fault for this god-awful tragedy, but that doesn't make me a monster. That makes me human. Thank you.
Oh, I was a
And I believe Bill Reed would like to speak to the court this time.
And this is her father, stepfather.
Thank you, Your Honor. Brief statement. It was a horrible tragedy for that wonderful lady. Helena to lose her life. Also be a tragedy to put my daughter Hannah in the penitentiary for that.
1 second. Let me slow him down.
She's alleged she introduced live ammunition on the set. That's not true. Why would she? The two people responsible for whatever come on the set are the vendor and the property master who had to work for her. On that terrible day, they had Hannah off the set doing prop duties, and she asked him, please bring her back on when Mr. Baldwin comes so he could do a final check on the gun and its instructions. They did not do that. If they had it, this horrible day would not happen. Thank you, Your Honor. Ladies and gentlemen of the court.
Thank you. Oh, I thought he would have a lot more to say than that, too. That was.
Thank you, Your Honor. And just briefly, Judge, I've made most of my arguments in the written pleadings. And Judge, it's nobody in this courtroom could not be moved by what we just saw. The family, Helena's family, her friends, it was a horrible tragedy. There's no doubt about that. And it's a tragedy for everybody. There were a number of lives changed, lost. That day, her friends talked about that. And that includes Ms. Gutierrez. I just want the court to know primarily that she has felt remorse. And maybe I've talked to her as much as anybody, at least on the legal side, Ms. Cisneros. She's cried. She's broken down. She's had mental breakdowns. She said, if only, many, many, many times. And it hasn't come out. It hasn't come out until today because of the legal proceedings and the system we have. But she has truly felt remorse, and I will tell the court that.
No, she does not.
As an officer of the court, that she has indicated that to me. This court has seen jail calls she's made. I would submit to this court that you could probably survey 100 people after something like this happens, including everybody that participated in the trial, scrutinize all of our calls, and pick out something bad that one of us said. Because, Your Honor, none of us are what we are on our best day, nor are we what we are on our worst day. And as Ms. Gutierrez said, she's human. She's flawed just like everybody else in this courtroom. We asked this court to consider fairness in respect that this was a cascade of tragedy. As some of the speakers indicated, there were multiple system failures by multiple people. Some of those people have come before the court, as this court knows, and received 6-month misdemeanor probation. Some have not been punished. Some have yet to come before the court. At least one individual is going to be tried in July. And so I know this court has the responsibility to weigh all of that and to determine what is commensurate and fair, as one speaker said, for Ms. Gutierrez. And what does that mean in the scope of things, and what has come before this court? And I'm asking the court to consider that. And also what probation might do for her in terms of rehabilitation, which is another goal of our system here.
Anything else?
It's not anything else.
No, you're right.
Okay.
All right, so I've made some notes along the way. So if I refer to the notes and I'm not looking at tables, it's because I'm reading. First of all, thank you for your presentations. Thank the friends and family of Helena for presenting their memories and their losses of Helena. There are really three choices for sentencing before me. What the defense wants is a conditional discharge. This means straight probation, unless Ms. Gutierrez comes back on a probation violation. She won't have a felony conviction on her record, so she can continue to possess firearms. Again, unless she comes back on a probation violation and receives the imposition of the probated sentence. The second one has not been offered by counsel, but I've certainly thought of it, and it's to continue her in the Santa Fe County Detention Center. That would be for 12 months. That's all she's allowed to stay at the detention center. And then put her on probation for the rest of the time. She's facing 18 months. She's got pre-sentence confinement for about a month or so. In this scenario, she won't experience prison. She will be a convicted felon. She cannot carry a firearm under federal law and for a specific time under New Mexico law. And then there's prison. And the state has proposed at 85% of the time sentenced to incarceration based on the serious violent offense statute. For all the fanfare and pundits and finger pointing that has been going on for over 2 years, we were able to seat a jury of her peers who confirmed that they could listen to the evidence received in court and determine the facts and apply the law. They found Ms. Gutierrez guilty of involuntary manslaughter. What were some of the poignant facts that came out during the trial? In her police interview, she proudly owned her position as armorer. On October 21st, 2021, chaos ended after the film crew walked off. Ms. Hutchins and others were trying to rig, if you will, how they were going to keep filming. And what was the defendant doing while waiting? She was loading Alec Baldwin's gun. Did she have enough time to load the weapon safely? Plenty. Did she load the weapon? Yes. With dummies in a live round. Did she check what she was loading? No.
No.
Why? Well, in her own words, most recently, in her jailhouse calls, she didn't need to be shaking the dummies all the time.
Oh, and she took the jail.
Did she check after that? No. And while you've heard her concerns about how she'll never work again as an armorer leading up to the trial, have her concerns changed? No.
You think she's still going to be
Here's
able to
what she
work?
says. This whole thing has been a character attack on her. Just recently in her allocution, I'm not a monster. And what did, where is it? They talk about how much of Hannah, on the phone, she and another are talking about how much of Hannah's life that they could take up, and that this is messing up her modeling career. This is while she's incarcerated, waiting for a sentence. And what does she say about the death of Helena? Hannah is dismissive of the judge talking about someone dying as a result of her actions. Hannah says she's looking at 13 months, which is ridiculous over what happened. Hannah says that people have accidents and people die. It's an unfortunate part of life, but it doesn't mean she should be in jail. A conditional discharge is not appropriate. And the second option of leaving you in the detention center would be giving you a pass you do not deserve. I did not hear you take accountability in your allocution.
No.
You said you were sorry. You were sorry, but not you were sorry for what you did. You were sorry for it and hope they can find peace. It was your attorney that had to tell the court that you were remorseful. The word remorse, a deep regret, coming from a sense of guilt for past wrongs. That's not you.
Oh, gosh.
You're hereby sentenced as follows. Stand.
Matt.
I'm sentencing you to 18 months of incarceration at a New Mexico Women's Correctional Facility. I find that what you did constitutes a serious violent offense. It was committed in a physically violent manner, a fatal gunshot, done with your recklessness in the face of knowledge that your acts were reasonably likely to result in serious harm. You were the armorer, the one that stood between a safe weapon and a weapon that could kill someone. You alone turned a safe weapon into a lethal weapon. But for you, Miss Hutchins would be alive, a husband would have his partner, and a little boy would have his mother. Please take her.
I felt like that was kind of a
I'm
smirk.
going to ask the deputies to watch how the courtroom gets cleared. Please do an order of remand to the transport order to the Department of Corrections and the judgment and sentence.
Yes, Your Honor.
All right. We are in recess.
All rise.
They got the corporal sitting with them. Okay. For the plaintiffs. Was her mom in the courtroom? I didn't see her. But also, do I know what she looks like? Probably not. That was tough. I'm going to let them exit here. I don't think there's anything to see here. So let's go ahead and jump into chat. The judge found knowledge, not a reckless disregard. She found knowledge that she did not check that gun properly and that she was responsible for it. Hannah, yeah, she said that just sitting in jail would be a slap on the wrist. So she got the maximum. Was anybody surprised by that finding? Let's see what the chat has to say. All right, if you guys got comments, make sure you go ahead and drop it in the chat section so we can get to it. We are at 70 likes. Our like goal for the stream is 75. So if you have not hit the like button, please do. It does help us out in the algorithm, and we only need 5 more likes to reach our goal for the live stream. So let's go ahead and jump into the chat. We got Ashley D saying the jail calls also solidified how I feel about the outcome of this case too. I know a lot of people were saying that they didn't think she was going to get jail time. So did anyone change their mind about that? Darlene said one of the calls was with the chick in the pink suit saying stupid things. Yeah, she's talking to her paralegal on the phone, which is not attorney-client privilege. You only have attorney-client privilege with your freaking attorney. What are you doing? Mary Malarkey says Hannah's sentencing, I only watched a few clips. Get ready for the judge remarks. I thought her remarks were going to be a little bit longer, but I am happy that she said them. I think she said what everybody was thinking. Indigo Bloop says, doesn't it literally play a recording saying that all the calls are recorded? Do they think no one listens? It's supposed to. That's my understanding. I also have not been to jail, so I don't know if it does it for every single call, but I assume there is. I think they say it at least on the other end, if not to the inmates, right? Tanya D says the phone advised her of that on every call. That's what I think. I think it does advise you. Chelsea B says, LOL, the paralegal is on the call telling her they are being recorded. She's so unremorseful. It's crazy. So the paralegal told her, has the actual recordings of the call been released? I've seen like some documentation of the state's interpretation of it, but I haven't seen anything come across my timeline that were the actual calls, and maybe I have to go and look for it. Kimmy Locker says to Chelsea B, not just saying they're being recorded, but saying something to the effect of, I bet that B word carries recording this call and other nonsense. It's the jail that's recording the call. Okay. Tanya D says, why was she chit-chatting with the paralegal? Not a smart move. Like I said, that is not attorney-client privilege. You get attorney-client privilege with your attorney, not his office. Indigo Bloop says, maybe she thought it when you call the cable company and it's only listened to if there's a problem. LOL. How do you not know this? Like, did she not see what happened to Donald Adelson? Did she not see what happened to her? Indigo Bloop said Hannah's facial expressions during this also were astounding to me. It looked like she didn't care. Even at the sentencing of like sending her to the prison, she looked like she was smirking, in my opinion. I could be biased. Ashley D says her fake crying, I'm sorry, but I fully believe that was fake. It just looks like bad acting. I agree with that. And the judge even said, hey, you had no remorse. You didn't even say you was remorseful. You're more sorry that you got in trouble, basically. Tanya D says she's got the Alex Murdaugh cry. I think hers was like a little bit worse. Chelsea B says she realizes she can't fake cry and stops trying eventually. Yeah, towards the end of it, she just kind of gave up. Ashley D, and you can always tell when she knows it's going wrong, she'll look down and she'll be like, dang, this is going bad. This is going real bad. It did not work. Ashley D said, we got to see some of the footage during the trial and it was so beautiful. She was very talented. And as much as I hate the movie being finished and coming out, I hope it wins her an award. I hope so too, because I know they decided to keep going with it. Rachel Mills says, I find it nice that he could have talked about himself as a victim as well, but he doesn't. Yeah, I like that too. That's for Joel Souza. And then we got Rachel Mills saying he probably has to do physical therapy and mental health therapy because of Hannah. Yeah, and he got shot in the, I believe, shoulder. So, I mean, yes, painful, but it's definitely not as bad as Helena, right? Indigo Bloop said, I don't know if the world will ever make sense again. Oof, that hit me right in the grief. I'm sorry about that. And I understand his feeling because that was his friend. She got shot in front of him. He also got shot, and it could have been worse for him too, right? Jamie F says, my heart breaks for all of them. They all were impactful. I agree. Unfortunately, we could not watch them all on this stream, but yeah, I think the effects that it had on her family, her friends, people that she worked with, the fact that they didn't even come to her funeral, they didn't send flowers, they didn't give any condolences. And when I'm saying I'm talking about Alec Baldwin and Hannah Gutierrez. She said, the mom said, I wish someone would have at least come and looked me in my eyes and gave me condolences. Only Helena's friends were there. That's sad. That's sad. Chelsea B says she's a massive brat, and from what I gather, everyone around her enables it. So much attitude, sorry for herself and nothing else. Exactly. She's like, I shouldn't go to jail for 13 months just because somebody lost their life. Like, she lost her life for life. It's been more than 13 months that she lost her life. So I think you'll be okay in jail for 13 months, ma'am. Like, come on now. And she's like, this is interrupting her modeling career? What modeling career? I thought she was an armorer. Small says, wait, is her hair pink? It's so pretty. Whose hair was pink? I don't know. Small says, what language is this? Russian? Ukrainian. I think it's called Ukrainian, but she was from the Ukraine. Darlene says she and her sister in the Ukraine. Yes. The mom and the sister. Rachel Mills says, I have a theory that the end of the video is something that was accidentally left in. One of Hannah's friends was doing a documentary on the incident and they may be using her footage. I don't think I noticed that. Tiny D says, I didn't appreciate the movie style production they added to the statements as far as like the captioning that they put. And it looked like it was being filmed for a documentary, not for, and like the way it was cut as well looked like it was a documentary, not a statement for the court. Small says to Rachel Mill, makes sense to me. That's surprisingly not an uncommon mistake. Rachel Mill says to Small, this is too nicely set up with light, etc., for it not to be something professional. Also, the cuts as well. Oh yeah, okay. So you guys were talking about the mom and the sister's setup, right? Indigo Bloop says, wait, this is Helena's mom. I thought it was Hannah's for some reason. I need more sleep. We are going to get to sleep soon. Kimmy Locker says to Indigo Bloop, no, Hannah's mom wasn't allowed to attend the sentencing because of her outburst after the verdict and the mess she and Hannah were talking about in the jail calls. Okay, I thought she was not there, but I didn't read anything on that. Indigo Bloop says, wow, Kimmy, I somehow missed that development in this whole thing. I have something to look up now. I did see the outburst. I saw that there was speculation about her not being able to attend, but I never confirmed. So thank you for that information, Kimmy. Indigo Bloop says, Helena sounds like such a beautiful soul. I agree with that. She made an impact on so many people too. Indigo Bloop says, I wish they went into the cause more in sentencing, but maybe that would be more insensitive to the victim's family. And I think it would be prejudicial because it was not stuff that was on the record. And which could lead to potential appeals and things like that. She's planning on appealing things anyways, but she's going to be in jail while she awaits her appeal. Just Me MD says, maybe it was a good thing that she didn't attend the funeral given the circumstances. The service was to celebrate life. I did not see where she and Hannah had even a close relationship. So no, ma'am. What she said that Helena was an inspiration to her and she will always be one. I felt that to be a lie from the beginning of the sentence to the end of the sentence. Indigo Bloop says she looks straight bored at this point, so clearly self-absorbed, which is like, how do you get that big of an ego? Ashley, like, oh, you're interrupting my modeling career? Like, ma'am, you were an armorer. Like, what modeling career are we talking about? You're gonna model handguns? What are you doing? And planning on how she's going to be able to still use guns despite being a convicted felon is wild, allegedly, according to her cause. Ashley D says, yeah, she came too hard with the fake tears in the beginning. It was bad. She was like, I'm crying. I'm like, girl, no. Just Tanya D says she's talking and saying nothing at all. She didn't say anything. Like, you could have sat down for all of that. You should have not testified like you didn't testify in the trial. Ashley D says, yeah, the musical interludes threw me off. It felt more appropriate for a celebration of life event than a courtroom. Yeah, the music with the photos, and also in the documentary, Alexis Carney says the way she makes this is all about her. I agree. Alexis also says she literally basically said, I'm sorry they made me out to be I'm sorry they made me out to be the monster. Yeah. I'm sorry that they're blaming me when it was really everyone else's fault. Ashley D says, exactly, Alexis, me. And her dad came in and said it was like the property manager's fault. Like, what? Darlene says, they'll screw the pooch. Indigo Blue says, I'm not a monster. Whoa. And she just, like, take a responsibility. Like, if I was truly remorseful, I probably would have took a plea deal. Like, sorry, I messed up. Let me just go, deal with it. Or if I went through trial and I got convicted, I'll be like, okay, I got to take it on the chin, but not, oh, please give me probation so I can be a model. Like, girl, what? Chelsea B says the judge today was fire. She was not entertained with Hannah's statements. Small says, what? That was her state? Dear God, I wish someone had written her statement for her. I think her attorney did. He didn't do a good job. Mary Malaki says, take a seat, Hannah. She should not have spoke. I think she would have been better off not speaking. She did not have any remorse. Rachel Mills says, I believe he's her adoptive father because her mom stepped out on him while they were married. He decided to adopt her. I thought he was the stepfather. Ashley D says, all while Dale was speaking, I was like, then you should have testified. That's what I was thinking too. But also he looked very concentrated, like he had memorized that whole statement and he was kind of staring off to the world weird. I don't know if I would have found him to be very genuine if he would have testified. Darlene says she didn't apologize to mother or express sympathy. She just apologized in general. To your family, and sorry that you guys convicted me, right? Kimmy Walker says Hannah and her defense team were the most damaging parts of her case from the start to finish. I can agree with that wholeheartedly. Just Me MD says, question, after this, do you think Alec will take this to trial or try to plea? I think he's going to take it to trial, and I think he's going to blame Hannah. I don't think he's going to take any type of responsibility. Darlene says she's big mad, and especially because they charged him even after Hannah, because they dropped his charges and then recharged them. They want him. They want to prosecute him, and I don't think they'll give him a good plea deal, if any at all. Indigo Bloop says, I'm really impressed with this judge speech and her note taking. Yeah, she did a good job. Tanya D says, Bowles just makes it worse. He did. She was like, your attorney is the one that said you had remorse. You don't even have remorse. I was like, geez. Small says, oh, Mr. Shine, the man who all but tanked her case. I think she was adding to it for sure. Rachel Mills says, wow, officer of the court, bringing out the big guns. Right. As an officer of the court, my client is remorseful. She broke down. Yeah, she broke down because she's going to jail, not because she's sorry. Ashley D says, sir, I understand you're doing your job, but you're coming real close to fibbing to the court. She probably did break down, feeling sorry for herself, not for what she did. Chelsea B says he really gets up here and says, please ignore all of her words. She's actually sorry. Yeah, she's actually remorseful. She said sorry. It was very empty sorry for sure. Couldn't even turn and look at the judge or anything. She just read the statement. I was like, all right, is that good enough? Kimmy Locker says, as someone said in another chat, is the remorse in the room with us? It was not. It was not. I don't even think her attorney believed she was remorseful. Darlene says she still has to stand trial for the guns in the bar. Yeah, that is another charge. This is not going well for her. I don't think she's going to be a model anytime soon. She might want to take a plea on that one. Amanda Lang says, while I was willing to believe that the prosecution's representation might have been biased, Hannah's comments at the hearing led me to believe the court absolutely got it right. And I believe that the court also heard the calls because the court quoted calls that the state did not. So Amanda Lang says, I mean, representation of the pros and cons. Yeah, of course, they're going to pull out the important part or the parts they feel is important, but the court also quoted it. And I believe the court actually listened to the calls. And she was probably disgusted in chambers listening to that. Tony D says, I think she would have left her in the detention center if it wasn't for the jail calls and her non-statement. I can agree with that. I think because she said, I did consider it. And I think that's what she was leaning towards, even though neither one of them talked about it. Rachel Mills says, I live for the shade. As far as the judge statement, Amanda Lang says, I think the jury got it right. I think other also needs to be held accountable. I would have accepted a light sentence until Hannah's call and allocation. Yes, a lot of people thought that she was not going to get the 18 months. A lot of people thought that she was going to get the suspended sentence. I said I would not be surprised if she gets the 18 months. A life was lost. And then she got on that phone. Oh, no. Rachel Mills says, I think she fashions herself some Insta model or something. Okay, well, maybe that career will still be there when she gets out. So good luck to her. Not really. Indigo Bloop says the only other people I've seen who can keep such a composed face work with middle schoolers. Rachel Mills says she threw the whole library at her. She did. And Kimmy Locker says, please take her. Yeah. Get her out of my sight. Shoo, shoo. Yes, that was a good line. Alexis Carney says, one of the most professional FU I ever heard from a judge. Yeah, she did. She did. Chelsea B says the judge said, get her out of my face. Carry on, right? Darlene says, as Nick Stroll would say, F all the way. F all the way off. F out of here is what she was like saying. Rachel Mills says her mom joked about going in disguise. Yeah, like what is wrong with them? Upside Down says, wow, sister, you learned nothing. Entitlement and self-centeredness did her in. If she could have just been quiet for a month that she was in jail? Come on now. Alexis Carney says, absolutely agree, Amanda Lang, and I'm against mass incarceration. So when I'm like, dude, they should probably be in jail. Like I really think really bad of what they did. Yeah. It's the no remorse for me. Indigo Bloop, and no responsibility. She's taking no accountability. Indigo Bloop says, I think she talked her way into prison with those recorded calls and utter lack of remorse and empathy. I agree. I forgot who said it, but she probably would have ended up just in jail without, I don't think she was going to walk. I don't think she was going to get the probation, but I think that middle level the judge was leaning towards until those calls. Alexis Carney said, and it's the same paralegal that was wearing a tiara in court, I think, day one. Was she wearing a tiara? I know she always came with her face beat. And I was like, that's a little bit of much makeup for a court, but okay. But I don't remember if she was wearing a tiara, but it is that paralegal. Ashley D says, oh, for sure. I didn't think she'd get the full amount until the jail calls. Yeah, I think that added to it for sure. Alexis Carney says, I don't judge women for what you wear in court, but I'll judge anyone for wearing a tiara or a crown in the court. Come on, right? Alexis says, and for a murder case, that's even worse. It's like, do you think this is about you? And then like she became friends with her client. I mean, with her office's client. Mary Malaki says, what you say, Bree? What did I say? I don't know. Yeah, Amanda Lang says, I totally changed my mind about sentencing after the calls in Hannah's allocution. Did she think the warning was like when you call tech support, like it isn't serious, like they just record it and they never review it? Maybe, I don't know. And to think that the prosecutor is actually recording these calls and then they bring it up during the hearing. Yeah, they weren't recording it. The state was recording it. Indigo Bloop says, for real, Alexis, it's wow. Why in the world would you want to draw that much attention to yourself in the courtroom too? Made Hannah look so bad, in my opinion. Agreed. Amanda Lang says, I'm sad about the additional hurt. Hannah's comments will call Helena's family and friends, or cause Elena's family and friends. And I'm glad the court heard it for sentencing. I agree. And hopefully they did not have to watch. I know some of them were there in person, but that was not an apology, right? Darlene says, well, she thinks jail is legal, is legal like summer camp. Yeah. So she should have fun. So what would prison be like? Boot camp? Indigo Blue says, right, I've always heard rule number 1 in court, don't draw attention to yourself outside of court, even in the office. Go for it. Be your extra fab self. She's going to be a model after this. Ashley D says, and it was at this place of work, a place he expected to be safe from a gunshot. It shook everything he thought he knew about the world. Yes. Amanda Lang says, Ashley D, absolutely. Something like that will fundamentally change how you experience the world. And he's not doing that work anymore. Ashley D says, Elena's mom hair looked pale pink. Oh, okay. I was like, what? Whose hair is pink? I couldn't tell if it really was or if it was white blonde and just her lighting and the way you turned your redder when upset made it look that way. I think her hair did have pink in it. I didn't change any of my settings. Well, no, I didn't change any of my settings. Tanya D says, I wouldn't want Hannah at the funeral. It's like Big Red going to Jimmy's funeral in the 5 Heartbeats. Bree probably doesn't know that movie. I do know that movie, Tanya. My mom made me watch it. Well, she didn't make me watch it, but she used to watch it. But no, I think this is just my opinion. It's not an opinion. It's a bad joke, but I think her mom might have wanted her there for other reasons. Her mom might wanted to handle Hannah. And I wouldn't be mad at her. I would not be mad at her if mama got a little bit of revenge. But I'm sure her mom's not that type of person. So I'm just talking to be talking, y'all. Hannah Lang says the captioning of Helena's mom was fine. Adding the music at the end cheapened the message, though. At least a message for the court. Yeah. I agree with that. Chelsea B says, I think Monolin might be in reference to her she got OnlyFans? What she got going on? That is a lot. Amanda Lang says, saying nothing at all. Now I have air supply stuck in my head. She should have said nothing at all. Darlene says they'll can tell them he locked them up and changed the combo ski the code, I'm assuming. Or she doesn't know it. Yeah, that's what she said, right? She can't be around those firearms. Alexis Carney says Hannah really had a coworker die because of her actions, and the entire time was more worried about how she looked. Yeah. Why did you guys sensationalize this case, basically? Amanda Lang says Hannah's dad is apparently extremely ill and having trouble breathing, so it could account for some of how he presented. Okay, that makes sense. I was like, either he's having a tough time or he really memorized his lines and he's trying to stay focused. Amanda Lang says Bowles made almost every single thing in the case worse. Yeah. Poor Bowles. Small says, am I the only one who thinks she's actually remorseful? What am I missing? I get immature, entitled, not evil, sociopath. Yeah, immature, entitled, and not remorseful. I don't think we're saying she's a sociopath. I just think that she's not taking it seriously, right? She thinks she should not be in trouble. Someone else should be in trouble because she's just a young girl. No, you don't get to do that and then tout around about being an armorer. Kimmy Locker says to Smalls, I don't think she's an evil sociopath, but I don't think she's remorseful because I don't think she accepts responsibility. I agree with that. Small says to Kimmy, oh, I see. I also missed the jailhouse calls. I think y'all are referencing. Yeah, the jailhouse calls are bad. Kimmy Locker says, yeah, she calls the jurors idiots and R slurs, laughs about her mom confronting the prosecutor in the bathroom, says the judge was bought off, and so much more. Yeah. Z says Hannah's dad, They'll Reed, who used to be a well-respected armorer working in film, has leukemia and is currently receiving ongoing treatment for it. It's sad, and he didn't want his daughter to go to jail. That makes sense. Upside Down says pro FY, well done. I don't know what that means. Chelsea B says she should be very thankful this happened in state where it was a 18-month max. I agree with that. She's lucky that the time is so short. Alexis Carney says, I just checked. It is day 1 in the morning. I believe that is a tiara in the paralegal's hair. Oh, wow. I didn't even notice it. Upside Down says, I think she's so thick into her entitlement, she's blind. Her parents own some of this. Yeah, I mean, joking with your mom about beating up the prosecutor? Like, what? Mary Malarkey says, check the likes, everyone. Dropping the B. And Small says 75. We hit our goal. Did we? Okay, yes, we are at 76 likes. Shout out to the Bree Hive. We have reached our goal. 3.5 hours into the stream. Shout out to the Bree Hive. I know we had a tough starting off with technical difficulties. My Wi-Fi didn't work, but we made it. And we are going to have a loud sound in 3. So turn down your volumes if you don't like loud sounds in 3, 2, 1. All right, we hit our like goal for the stream. Shout out to y'all. And we just got through all the comments. Thank you, everybody, for chatting in the chat. Your girl is tired. Talking for 3.5 hours is a tough gig, okay? But I appreciate you all for staying and hanging in there with me and giving us all your thoughts on everything that has transpired in these cases. And hopefully we'll have something really fun to cover on the next live stream. But with that being said, your girl got to go to bed. Thank y'all all so much. I will see y'all all on the next live stream, which is on Thursday. Bye.